Good morning, ladies and gentlemen. It's an absolute pleasure to welcome you all today to this conference. I would at this point in time request the dignitaries for the first session, the inaugural session, to please join us on stage. Justice Hima Kohli, Judge, Supreme Court of India. Justice Mahesh Sharad Chandra Sonak, Judge, Bombay High Court. Mr. Arun Chawla, Mr. N.G. Khaitan, Ms. Geeta Luthra. Please join us on stage. Mr. Coelho Pereira, Senior Advocate and High Court Bar Association President. Ms. Geeta. Welcome everybody to the conference today on the theme of access of justice through arbitration and mediation in commercial disputes. The organizer of today's event, the Indian Council of Arbitration, is the apex arbitral body in India. It was founded in 1965 as an arbitral body of national importance through the joint efforts of the Government of India and FICCI. Since its inception, it has been steadfast in its mission to facilitate amicable, swift, and cost-effective resolution of commercial disputes. In the current landscape, ICA not only is recognized within India, but in several key arbitral jurisdictions. Ladies and gentlemen, we are extremely privileged that we are joined by some of the best legal minds of our country to enlighten us and ignite our imagination on hot topics in the arbitration landscape. Gracing the event today, we have Honorable Justice Hima Kohli, Judge, Supreme Court of India, to lead this discussion with her scholarly insights. I request Mr. N.G. Khaitan, President of ICA, to formally welcome Justice Kohli with a green certificate. This green certificate is a pledge by ICA to plant 6 trees through its initiative. Now, I request Mr. Arun Chawla, Director General of ICA, to welcome Honorable Justice Sonak with the green certificate. Now I request Mr. Coelho Pereira, Senior Advocate and President of Goa High Court Bar Association, to welcome Justice Kohli and Justice Sonak by presenting a memento on behalf of all the members of Goa High Court Bar Association. Taking the event forward, I would now like to invite Mr. Arun Chawla, Director General of ICA and former Director General of FICCI, to address the gathering with his opening remarks.
Good morning, ladies and gentlemen. It's a great honor to address this August gathering with participation from senior members of the judiciary, legal fraternity, and dispute resolution practitioners. They all act as the pillars for India to become the most preferred destination for dispute resolution. As India's economy becomes increasingly interconnected with the rest of the world and exhibits dynamic growth, the demand for efficient, fair, and swift resolution of disputes has never been more critical. This was even emphasized by the Government of India at various forums and recently at the Supreme Court's 75th anniversary celebrations. So, this highlights the focus on access and ease of justice. Ladies and gentlemen, it is often said that inordinate delay, cost of legal processes, and inaccessibility are impeding the effective delivery of justice. These issues especially aggravate the situation when it comes to economic transactions, where value in hundreds of thousands can be lost in a few minutes. It can also impede investments and ultimately the growth of the economy. So, to ensure timely, cost effective, and accessible solutions, it is most pertinent to have credible alternate means of dispute resolution like arbitration and mediation. And of course, appropriate institutions to deliver. Ladies and gentlemen, it is also important to note that the alternate dispute resolution is now becoming more than a dispute resolution in the strict sense of the term and also encompasses conflict avoidance, conflict management, and conflict resolution. For example, in elder mediation, the mediation may focus on planning the future care of the older members of the family. A further example includes succession mediation, where family members come together at mediation to plan the succession of the family business to the next generation. Therefore, ADR is being used not only to resolve actual disputes, but also to prevent potential disputes between parties. It is also pertinent to note that mediation clauses are now regularly included in commercial contracts, supplementing more traditional clauses that refer arbitration only as the appropriate mechanism for resolving disputes. In this background, the theme for today's conference, Ease of Justice through Arbitration and Mediation in Commercial Disputes, reflects our shared commitment to exploring avenues that facilitate easier access to justice. It underscores the importance of harnessing the potential of arbitration and mediation to provide streamlined and less adversarial path to resolving disputes. This approach not only reduces the burden on the traditional legal system, but also empowers parties involved in disputes with more control over the process. Today, we are privileged to have with us Honorable Ms. Justice Hema Kohli, an eminent judge of the Supreme Court of India. Justice Kohli has significantly contributed to the concept of fairness and justice in India's judicial landscape over her illustrious 17-year career as a judge after having gained a wealth of experience at the bar. She majorly contributed towards women's rights, first woman chief of the Telangana High Court, and is an inspiration to women in particular. Let's give her a big round of applause. We also welcome Honorable Mr. Justice Mahesh Sharat Chandra Sonak, Judge, High Court of Bombay at Goa. Justice Sonak's elevation to the High Court in 2013, after more than 25 years of experience at the bar, is a testimony to his widespread and valuable experience. As the senior-most judge in the Goa bench, Justice Sonak has led many initiatives to promote the ADR practice in Goa. So we are truly indebted to your support for this conference. The technical sessions feature distinguished speakers who bring stupendous knowledge and experience in law, arbitration, and other alternate dispute resolution mechanisms, having practiced not only in the Indian legal framework, but also other key arbitral institutions in the world. Their insights will undoubtedly enrich our discussions and understanding throughout this conference. I must acknowledge that the two moderators of the technical session, Ms. Pinky Anand, Senior Advocate of Supreme Court of India and former Additional Solicitor General of India, and Ms. Geeta Luthra, Senior Advocate, Supreme Court of India and Vice President of ICA, they cancelled their commitment with an international delegation to join us in this conference. Let me also express my sincere gratitude to Mr. J. Coelho Pereira, President of the Goa High Court Bar Association, for their invaluable support. And of course, Mr. Girish Agni, Secretary of the Goa High Court Bar Association. I also appreciate all the delegates who have joined us for this conference. I must not miss the esteemed professors who've joined us from the institution of, from the university. This is IIULER, Goa. And I'm very, indeed, extremely thankful for these academicians to join this conference, which will actually be, be a point of starting point for all the communities, all the stakeholders to join hands and take this process of alternate dispute resolution forward. So as we inaugurate this conference in the beautiful state of Goa, let us reaffirm our dedication to the development of a culture of effective alternate dispute resolution, one that upholds principles of fairness, impartiality, and integrity. So once again, thank you very much for joining us at this conference. A big clap for all the dignitaries present here. Thank you.
Thank you, Mr. Chawla, for giving us a comprehensive overview of the topic. I will now invite Mr. N.G. Khetan, President of ICA and Senior Partner, Khetan and Company. Mr. Khetan is a distinguished figure in the legal and business community. Over to you, sir.
First of all, good morning to you all. I've been to Goa many times, and I have never been in formal attire. It's always been shorts and t-shirt. I think this first time I'm in formal attire, and I'm seeing people in real jackets. Because when I come to Goa and stay in hotels, nobody is in jacket and tie. So this is a new Goa to me today. Grateful to Justice Kohli. I mean, actually, we consider her as a part of an ICA family. Whenever we have a conference, we make a request to her, and she always gives us a supporting hand. In fact, I would say that she is a torchbearer of ICA, if I can use that language. Today also we have Sri Maheshji Sonak, who is the judge from Goa, Judgment Goa. We have Mr. Pereira, who is going to make some announcement after we are over. Mr. Chawla had introduced all the dignitaries who are going to speak today and who have come all the way from different parts of India. In fact, two stalwarts of arbitration law, Ganeshji, Chandru, and Tejas Karya, they are here also. I say that if there is one voice in India in arbitration and mediation, that is Ganeshji and Tejas. So thank you for being here, because the country listens to you as far as the law of arbitration is concerned. In fact, today's subject, I mean, this has been a very, very important subject for ICA. Ease of justice through commercial dispute resolution. It is not actually ease of justice, it is basically ease of living also. Because without ease of justice, without ease of living, neither there can be human development, nor there can be economic development. And the most important thing in our life is to be happy. And we can only be happy when we have an ease of justice and we have an ease of living. So, how do this arbitration, mediation, and commercial and resolution of commercial disputes makes our life better and easier? I joined this profession as an article clerk in 1970. Those days, there used to be an attorneyship examination, I think you would not be aware of. Calcutta High Court and Bombay High Court used to have attorneyship examination. And the examinations were conducted by the Calcutta High Court. We were not required to go to any university. There were we used to be given 6 questions. We had to answer 5. The paper used to be set by the judges of the High Court and the registrar of the High Court. And about 30 to 40 students used to appear, and the passing mark used to be 66%. Very few students used to go because it was a very tough examination. But then we had an advantage that we could wear a black tie, black coat. As an article clerk to the lawyer, we could also mention the matter before the judges. We could also appear before the registrar, and we could also appear before the master. Today it's not so, because in 1977, when Janata government came to power, they abolished this examination because they said that the people who pass attorneyship examination, the commercial world, I mean the business organization, looks for them. Like today we go to different universities to select law students. They used to select law students actually who have passed the attorneyship examination. And in those days, I remember the mediation or conciliation or arbitration, whatever you may call it, was basically done by the leaders of the business community. I mean, if there was a dispute between a business family, they would go to a particular leader of the business community, or they would go to a senior member of the family, or they would go to the senior solicitor of a law firm, and they would try to resolve their dispute. Very few matters used to go to the arbitration because it was a very, very long drawn process. It was basically a panchayati raj system where you used to resolve our disputes during the Mughal Empire, Mughal days and British rules. It was basically when the Britishers came to India that they wanted the disputes to be settled through the court of law on a basis of common law. It is in last few years that people have realized that if we want to resolve disputes, not only commercial disputes, all kind of disputes, family disputes, any kind of dispute, the best way to do it, do through mediation, conciliation, or arbitration. And I still remember that I was invited in the Supreme Court of Virginia once in America to speak. And there, my subject was also mediation. I spoke on mediation, and then there were 4 speakers who spoke on mediation. And after our session was over, I spoke to them. There were 4 lawyers. So they said, we have left practicing in the court. We have become full-time mediators. And we are resolving more than 50% of the commercial disputes or family disputes through the process of mediation and conciliation. It is basically, the court in America is basically looks after the criminal cases which cannot be resolved through mediation and conciliation. But most of the commercial disputes are resolved through mediation. And if the mediation fails, then it goes to arbitration. And incidentally, I was also watching a cricket match in Dhaka. It was a World Cup cricket match. And I had a lawyer sitting by my side. after a few, he was with his son also. And then we started talking, and I came to know that he's a lawyer from Karachi. Uh, so, whenever we see anybody from Pakistan or Bangladesh, we become very curious because they are part of India. And then he told me, interestingly, that Mr. Khaitan, we regularly subscribe to Supreme Court cases and we regularly subscribe to AIR. Same thing, I was in Bangladesh recently. I took a delegation, and same thing when I met the bar there, same thing was there. I mean, though of course they cite in Urdu, but they like to know that what is the law which is being pronounced on commercial law in India. Same thing is in Sri Lanka. So the point in here is that we have so developed ourselves in the branches of commercial law. Taxation law is different fiscal laws are different in different countries. But commercial law, we are one of the leading country who interprets the scope and the ambit of the commercial law. Now, when we are leaders, why can't we make India also a leader of conciliation, mediation, and arbitration? I think the judiciary has realized now. It has realized that, yes, that this particular branch of law has to be encouraged. The judiciary has also realized that institutional arbitration is the only way where the mediation and arbitration can be successful. Institutional arbitration is the only way when people can resolve their disputes in a time-bound manner and in a cost-effective manner. The only issue is that the institution must have a panel of arbitrators whose integrity and honesty is beyond doubt. They take arbitration as a serious subject. The lawyers takes arbitration as a very serious subject, not as a part-time profession. We have to train arbitrators. I mean, anybody can say, I will be an arbitrator. It's it. Anybody can't be an arbitrator. Anybody can't be a mediator. We need to have specialized institution, or if not institution, special classes where we call renowned arbitrators from different parts of the world and give them training. Similarly, we need to ask mediators from different parts of the world and give us training. It is very, very necessary. And I'm sure it is going to happen. It's a question of time, it is going to happen. The arbitration law has gone number of times, number of changes. When we keep on amending the law, people feel that the law is not, there is no certainty of law in India. We must bring certainty of law in India. I mean, recently also, there is a report has been submitted that the Arbitration Act conciliation requires number of amendments like appointment of emergency arbitrators, third-party funding, promotion of institutional arbitration, time limit within which the pleadings has to be completed. These are all, I'm sure these will come in a very short time. And I'm sure once this comes and once the judiciary treats that no, they will not interfere in the arbitration matters, I think our life will become much easier and we'll be much happier. Thank you very much. Thanks a lot.
Thank you, Mr. Khaitan. We will now go to the special address for which we have with us Justice Sonak. Please, sir.
Honorable Miss Justice Hema Kohli, Judge, Supreme Court of India, Mr. Arun Chawla, the Director General, Indian Council of Arbitrations, Mr. Khaitan, President of ICA, Ms. Geeta Luthra and Ms. Pinky Anand, Senior Advocates, Supreme Court of India, Mr. Coelho Pereira, President of the Goa High Court Bar Association, distinguished speakers at the technical sessions, dignitaries of the days, esteemed delegates, members of the bar, ladies and gentlemen. I welcome you all on behalf of the Bombay High Court at Goa. We are extremely grateful to the ICA for choosing Goa as the venue to host this conference. We are also grateful to Honorable Ms. Justice Hema Kohli for gracing this inaugural session of this all-important conference and agreeing to deliver the keynote address. To begin a conference with a keynote address by someone as experienced and as knowledgeable as Justice Hema Kohli is indeed to begin on an excellent note. Justice Kohli, let me say that you have set up an extremely high benchmark and you have raised that bar even higher by telling everyone that this is not a benchmark, but this is only a starting point. Thank you very much. So thank you ICA and thank you Justice Kohli. Friends, the latest World Bank report ranks India 63rd in the rankings of doing business. Now, this may have been a significant jump from the previous rankings, but still there is much ground to be covered, particularly by those of us who are concerned with the administration of justice. One of the significant parameters to determine the ease of doing business rankings is enforcing contracts, procedures, time, and cost to enforce the debt contract. Regarding this parameter, India stood 168th out of the 190 nations in 2018. Now it fares slightly better at the 160th position or so, but this is hardly any significant improvement. This report notes that it would take about 1,445 days, that is about 4 years, to resolve a commercial cause in India, and 30% of the claim value goes to recover the claim. About 2/3 of the time is spent on the trial and judgment phase, and the balance 1/3 on the execution of the judgment or award. For all these reasons, this report gives India only 10 points out of the maximum 18. This is indeed regarded as a poor score. These figures may have improved, but only slightly and not significantly. Now, India's judicial system is castigated as the prime culprit for the difficulties in contract enforcement. This one parameter, along with the parameter for getting building permits, contributes most to our relatively poor ranking in the ease of doing business, or more particularly, the ease to justice through well-established judicial procedures. Now, there are several reasons for this unfortunate situation. Those within the judiciary argue about the stepmotherly treatment when it comes to the judge population ratio or even judicial infrastructure. Despite our economy having quadrupled in the last 2 decades, there is no proportionate increase in the judge population ratio. These statistics are well reiterated from time to time. Most developed countries have about 50 judges for a population of 1 million. The US has about 100 judges for a population of 1 million. But in India, we have about 15 judges for a population of 1 million. Now, apart from this skewed judge population ratio, we still cling to the archaic and time-consuming procedures, contributing to the enormous delays. There is little fear or apprehension about raising false and dishonest pleas. Rarely do the courts initiate action for perjury or award any costs which are proportionate to the cause. The state is one of the biggest litigators, even in commercial disputes. The state is an interpersonal agency functioning through its officers and bureaucrats. Here again, the culture is to assume no responsibility whatsoever. This is sometimes for downright dishonest reasons, and sometimes because the officers or bureaucrats do not want to be accused of dishonesty. The attitude is it is better if the courts decide the matter one way or the other. Now, all this results in the state, through its taxpayers, shelling out excessive amounts towards interest, penal interest, compensation, etc. The private contracting parties are naturally frustrated with this entire process. The adversarial system often promotes conflict and non-cooperation. It seeks proof rather than truth, resolves a conflict, but rarely solves a problem. It is lengthy, costly, and often provides inadequate remedies. It is not as if the legal systems in the other part of the world, including Europe or America, have not gone through this unfortunate phase that we are going through. Charles Dickens' writings bear a very eloquent testimony to the state of legal affairs in England during the 18th and 19th century. Most of these countries, particularly the Southeast Asian countries like Singapore, have turned to and invested in ADR through conciliation, mediation, and arbitration. They have invested in developing an ADR culture. All stakeholders are alive to and impacted by this culture right from the stage of contract formation. This is necessary because ADR requires the stakeholders to see the long-term benefits of a private dispute resolution. Convincing parties or lawyers about the benefits of ADR once a dispute arises and giving up the perceived advantages of litigation becomes much more difficult. We must develop an ADR culture in India, which is best developed through dissemination. Therefore, conferences such as the one which ICA has graciously organized is extremely important. Simultaneous with developing ADR culture, we must disincentivize resort to frivolous litigation aimed only at exploiting our unfortunately tardy legal process. The contracting parties are very often fully aware of their breaches, of their weaknesses, but would resist enforcement simply because it is commercially profitable to do so. The law's delays or the vagaries of litigation encourage unethical practices and also incentivize taking of chances. This attitude and culture has to change. One of the major stakeholders, as I said earlier, even in commercial disputes, is the government or the public sector undertakings. They must be sensitized about the virtues of ADR. In fact, ADR should now form one of the most important components of our national litigation policy. Justice Sri Krishna suggested that this policy should now be renamed as National Dispute Resolution Policy rather than National Litigation Policy. The general focus of legal training in India is on dispute resolution through court proceedings, or at least the threat of court proceedings. Professional lawyers should look after their clients' best interests, but they often need more training to dispense professional negotiations. Law schools in India should now concentrate on aspects of legal training that prevent disputes from spiraling into emotional diatribes and build capacities and skills to negotiate, mediate, settle disputes, if not to prevent them. In a write-up by Mr. Ramanuj Mukherjee in The Wire, he points out that in Singapore or even in the US, contracts are enforced within a matter of weeks or at maximum some months. Countries like Singapore, Hong Kong, Dubai also have a robust regime for enforcement of arbitral awards. The threat of enforcement disincentivizes parties from opportunistically breaching contracts, thus keeping the business ecosystem reliable and trustworthy. The lack of a credible legal alternative to enforce contracts swiftly and without hassles emboldens the parties to breach contracts. In such cases, only mediation may not always be of great help. Arbitration is possible. However, even arbitration has its own problems regarding high costs, delays, excessive judicial interference with awards, and execution issues. A hybrid model of combining mediation and arbitration is being explored with fairly encouraging results. Our Honorable Chief Guest, Justice Hima Kohli, has written an excellent paper on this hybrid model of MED-ARB. She writes, and with your permission, I quote, MED-ARB is an efficient tool for dispute resolution in terms of time and costs. It gives greater play in the joints to the parties as it combines voluntary techniques of persuasion, which are most important for mediation. MED-ARB is a process which does not insist on one size fits all. It allows for a softer mediation process by exhausting every possible opportunity to achieve a resolution to a dispute voluntarily and peacefully. I really appreciate the emphasis on voluntary dispute resolution, and that too in a peaceable manner. This process strikes a perfect balance between party autonomy and the finality of a dispute resolution. The focus is on sustaining the relationship between the parties and at the same time effectively resolving the disputes. Resort to ADR is now inevitable, but this should not be done only to reduce the arrears in the courts. Reduction of the pressure on the docket of the courts is certainly one of the objectives. But to quote our present Chief Justice of India, Justice Chandrachud, he explains that mediation as a procedural intervention in the legal system fulfills other instrumental and intrinsic functions of equal, if not greater importance. In its instrumental functions, mediation is a means to fulfill the stated objectives such as quickness, reduced costs, informality of procedure, and greater participation of the parties in the process. But the intrinsic function of mediation emphasizes that mediation is an end in itself. The peace that mediation is able to achieve is much more enduring and satisfying than a verdict through usual litigative process or even an award in an arbitral process. It is trite that litigation involves delays, expenses, rigidity of procedures, and even minimal participation of the parties themselves. J.S. Orbach, in his classic piece, Welcome to Litigation, says that it is virtually impossible to survive litigation and yet remain solvent. But it is occasionally possible to endorse it and remain sane. As a modern ordeal by torture, litigation excels. It is extraordinarily expensive, agonizingly slow, and exquisitely designed to avoid any resemblance to fairness or to justice. Yet, he says, yet in strange and diverse ways, it does settle disputes, but to everyone's dissatisfaction. All this at least has a chance to be minimized, if not eliminated, by resorting to ADR instead of litigation in the first instance. Recently, I read a piece by Joseph Markowitz, an eminent mediator, analyzing President Lincoln's 3 quotes on conflict resolution. Let me share them with you before I conclude. In the first, President Lincoln says, discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. Lawyers owe a solemn duty to explain to their clients the full range of costs, timelines, and even the frustrations before taking the first step into litigation. Greg Relia has made a comparison between lawyers and gladiators. He says that the present-day lawyers battle with arms of logic instead of lances, with statutes instead of swords, with rhetoric instead of physical force. But now he says there is a dire need for lawyers to transform themselves from gladiators to mediators. Judges too need to develop a culture and an environment that encourages the resolution of disputes through ADR. In the second, President Lincoln says, quarrel not at all. No person resolved to make the most of himself can spare time for personal contention. Still less, he can afford to take all the consequences, including the vitiating of his temper and loss of self control. Yield larger things to which you can show no more than equal rights, and even yield the lesser ones, though clearly your own. Better to give your path to a dog than be bitten by him in contesting for the right. Even killing the dog would not cure the bite. Friends, most of you will perhaps justifiably say that this is all very easy to preach but extremely difficult to practice. This is possibly because in the times in which we live and the manner in which we are conditioned to think, fighting comes so naturally to us. But think again. It no doubt takes a little while to realize that never quarreling is a much more successful strategy. Once we decide we are not going to quarrel, what are we likely to do instead? We are at least likely to be open to listening to whatever proposals the other side may make. We are at least likely to come up with some proposals of our own, which we may perceive as having some chance of acceptance from the other side. In this manner, we create an environment where mutually beneficial solutions stand a good chance to emerge. In this manner, we are creating an environment where the conflicting parties are at least willing to listen more than to simply talk. This is certainly a fertile ground for mediation. In fact, one of the essential attributes of mediation is to create an environment in which the parties are at least prepared to listen to one another. Listen with respect, not just as lawyers do, most of the time with a view to repartee or respond, but listen with a view to understand and, if possible, appreciate the other person's perspective, the other person's concerns or anxieties. All this requires the mediator to invest quality time listening to the parties at the caucuses, or at least at the joint sittings, or preferably at both. Dean Rusk once said that one of the best ways of persuading others with your ears by listening to them. Finally, President Lincoln's third quote is his shortest and most profound and perhaps the hardest to follow. He says, "Do I not destroy my enemies when I make them my friends?" An enduring peace can only be achieved by recognizing our shared humanity, recognizing that no other must be destroyed to achieve true peace. The idea expressed so elegantly by President Lincoln is perhaps the birth of what we now call as transformative mediation. This method exhorts the parties to change something in themselves before they can solve conflicts. Using any other method still leaves you with enemies or forces you to annihilate them. Making an effort to understand their concerns can eventually lead to a more genuine peace. Businesses can genuinely bloom in such a setting. In conclusion, dear friends, let me leave you with an idea from John Gardiner's book, Recovery of Confidence, written perhaps in the 1960s. He speaks about institutions being caught in a savage crossfire between unloving critics and uncritical lovers. On the one hand, you have these unloving critics, people who see absolutely no good in the current state of affairs and will do everything they can to criticize and tear it down. On the other hand, some uncritical lovers hold on desperately to the status quo. These people go to any extent to resist change. John Gardiner suggests that we must become loving critics, which means that we must be open to the winds of change and embrace them as we hold on to what is fundamentally important. From the deliberations to follow, if we succeed in producing even a handful of loving critics, to borrow Gardiner's words, I think we can say with confidence that the way forward is bright and not bleak. If our hopes thus far have been liars, I am sure that our fears may as well turn out to be dupes. Once again, thank you very much for this invitation and thank you for hosting this conference in Goa. Thank you very much.
Thank you, Justice Sonak, for an enlightening address and adding depth to our discussions. I will now invite Justice Kohli to share with us her views on the topic.
Very good morning. It's not often that I come to Goa with spectacles and pencils in hand with a speech. It's always been a pleasure and a privilege to come here as a tourist, looking forward to some excellent cuisine, some great beaches to visit, and some lovely friends to meet. We are doing all of that, and above all, meeting today on a subject which is close to all our hearts. So I'll start by acknowledging my distinguished guests on the panel. Justice Sonak, who spoke so beautifully and wrapped up the whole subject. Mr. Khetan, who didn't touch his written speech and spoke extempore wonderfully. Mr. Arun Chawla, a man of all seasons, Director ICA. Mr. Pereira, Senior Advocate and President, Bar Association of Bombay, High Court of Goa. Our tea before we assembled here has been very fruitful if we go by what he has offered to ICA. To carry forward the spirit of arbitration, we'll wait with bated breath for it to formalize. Ms. Geeta Luthra, Senior Advocate and Vice President, ICA. Senior advocates amongst the audience, distinguished academicians, ladies and gentlemen, good morning. It's an honor and a privilege to attend this conference organized by the ICA, and we've gathered to delve into a topic of paramount importance, ease to do justice through arbitration and mediation in commercial disputes. The conference gives us this opportunity to discuss our collective efforts towards broadening the reach and efficacy of international arbitration by embracing and fostering diversity and inclusivity. In today's world, thanks to globalization, everything is moving at a fast pace. This has led to increased commercial transactions with businesses spanning across cultural and geographical boundaries. At the same time, this has thrown up a variety of legal challenges. International trade and investments have grown phenomenally, making dispute resolution more complex. Disputes can now affect not only the parties involved, but the entire global community. To address these challenges, ADR has emerged as a powerful tool for businesses. ADR is known for its flexibility, efficiency, and adaptability, making it a valuable for navigating the complexities of global business. Just as an introduction to ADR, we all know and we are proud of the tradition of conflict resolution through consensus and conciliation. Mr. Khetan had touched upon it when he talked of various traders, guilds, and leaders of the industry resolving disputes without going to the courts. The concept of arbitration harks back to the panchayat system or the village council, where disputes were amicably resolved through collective deliberation. And this ancient tradition is steeped in the ethos of community participation and consensus building that reflects our country's commitment to inclusivity and harmony. The term ADR encompasses several models, including the Lok Adalat, which is also a facet of ADR, arbitration itself, mediation, conciliation, negotiations, and most recent modes, the hybrid modes, MED-ARB and ARB-MED-ARB, that Brother Sonak just touched upon. So these dispute resolution methods have been termed as alternative. Why? Because litigation is still considered the primary mode. Let us remind ourselves that by no stretch of imagination, and I emphasize that, is arbitration meant to mirror litigation. We must ensure that arbitration in India or any jurisdiction does not take a backseat but occupies a co equal, if not a primary role in the legal landscape. I'll now touch upon a few subjects which might be of interest to some of us. Firstly, India as an emerging global platform for commercial arbitration. In recent years, India has made significant strides in establishing itself as a reliable partner in arbitration and mediation services. India's transformation into a commercial arbitration hub, driven by the judiciary's unwavering commitment to fast tracking matters that fall under the Arbitration and Conciliation Act and fostering a pro enforcement regime, is undeniable. The 1996 Act, as we all know, was following the UNCITRAL model law of arbitration. And what was the object? The object was of settling disputes arising from international commercial relationships in a fair, in an efficient, and an expeditious manner. So, even for disputes that require urgent intervention and redressal, such as those in the case of breach of contracts, preservation of assets or evidence, we have the concept of emergency arbitration that has emerged. With the rise of institutional arbitration, recognition and enforceability of orders passed by an emergency arbitrator is bound to reduce the civil and commercial dockets of our courts. Coming next to the institutional arbitration and the concept of arbitration bar of India. The upsurge of institutional arbitration in India requires fostering of a specialized arbitration bar. Such a bar, composed of experts, of legal practitioners solely engaged in arbitration, would have to be collaborative and closely established with arbitration institutions. This symbiosis would streamline the arbitration process and serve as a proof of concept, demonstrating the arbitrator's viability as a primary form of dispute resolution. Such a focused approach will also elevate the arbitration landscape, positioning it as an equal, if not superior, alternative to traditional court litigation. A specialized arbitration bar will also encourage a cultural shift in the legal community, positioning arbitration as a niche field of expertise. It will attract fresh talent and eventually call for specialized arbitration tribunals, perhaps at high courts and at district levels, akin to commercial benches. So, regular workshops and training sessions and programs like the present one will help streamline every facet of the arbitration process, starting from drafting, ending with enforcement. They'll also help boost the domestic and international confidence in India as an arbitration hub. Next, I'd like to just touch upon the judicial precedents emphasizing finality and pro-enforcement approach. I know we are all part of the legal fraternity, so I'm not going to emphasize much on the jurisprudential aspects except what is prominent and latest. So there have been several landmark judgments that demonstrate that India is committed to upholding the sanctity of arbitration awards and that the courts do not act as an appellate authority to reassess the merits of an arbitration award unless and until there are compelling reasons to do so. So, in the Balco case, the Supreme Court had sent a strong message to the international business community regarding the pro enforcement stance of the Indian courts. In Vijay Karya, the Supreme Court had underscored the importance of considering party autonomy in the arbitration process. In Amazon, the Supreme Court held that the interim award passed by an emergency arbitrator is enforceable and there is nothing in the Act that prohibits the contracting parties from agreeing to a provision that provided for an award to be made by an emergency arbitrator. in a recent 5 judges bench of the Supreme Court that has upheld the group of companies doctrine in the case of Cox and King, it has clarified that non-signatories may be bound by arbitration agreements if there is a mutual intention, a concept that is distinct from the alter ego principle. This doctrine, rooted in contractual and corporate law, aims to discern the intentions of the parties in multifaceted transactions. It was determined that in such cases, that it is the arbitral tribunal rather than the referral court who should decide on the aspect of the binding status of a non-signatory. So the Indian Supreme Court, by limiting judicial intervention and respecting arbitration awards, has bolstered India's reputation as a favorable venue for dispute resolution. This judicial philosophy complements the legislative reforms and signifies India's ambition to become a global hub for arbitration. Coming next to mediation, another important tool of ADR. So I have seen firsthand how mediation can be a powerful tool in helping parties find mutually beneficial solutions that can avoid costly and protracted litigation. When it comes to resolving commercial disputes, arbitration and mediation are both important ADR mechanisms. Although both methods effectively resolve disputes outside of traditional litigation, mediation, friends, offers that unique benefit, making it a preferred choice for parties who want more collaborative and a flexible approach to conflict resolution. In India, mediation, as we all know, can be court annexed or private or provided by institutions and covers statutes like the Commercial Courts Act, the Consumers Protection Act, the Companies Act, and not to forget the MSME Act of 2006. So mediation services in India are provided by private ADR centers, which is now coming up, happily so. Mediation centers and centers set up by courts or tribunals that coexist. And as per the data published by the National Legal Services Authority for the year 21-22, you will be surprised to hear that India has 464 ADR centers, out of which 397 are functional, 570 mediation centers, 16,565 mediators, and still counting, and nearly 53,000 cases settled through mediation. Let us also acknowledge a significant milestone in the Indian legal landscape, the Mediation Act 2023. This legislation is not merely an act, but it is a testament of our collective yearnings for a more efficient, more harmonious, and less adversarial method of dispute resolution. It offers autonomy to parties to solve their differences creatively, preserves relationships, saves both time and resources. So while no single approach can be a panacea for all the legal challenges, the Mediation Act provides a promising addition to our toolkit, encouraging dialogue over discord. COVID-19, we can't but help mentioning it in the context of ADR. COVID-19 pandemic has brought about an unprecedented global crisis that has affected all aspects of life, including our judicial process. In India, the pandemic has made the courts and the lawyers adapt and evolve to face the challenges of the current times. Just on a lighter note, and we were just speaking about it a few minutes before we assembled here, when courts were being conducted virtually, one of the most hottest destinations was Goa, where most of the lawyers that we were aware of decided to park themselves and connect virtually to almost all courts that were functioning virtually across the Supreme Court and the state high courts. So that shows the popularity of Goa as a preferred destination. I can also share my experiences on how the COVID times worked for us. When I was presiding as a division bench in the Delhi High Court just before the lockdown was declared in March 2020, My bench partner, Justice Prasad, had flown down to Chennai from Delhi to be with his family, and he couldn't return back because all the flights were cancelled. Separated by a distance of over 1,700 kilometers, we seamlessly conducted court online for almost 1 month. Again, when I went as Chief Justice to Hyderabad, one of my colleagues at that time had traveled to meet his family at Chicago. That was around June of 21 or May, I think. And he could not return to India because of the lockdown and cancellation of flights. So our IT team in Telangana linked him up with his bench partner in Hyderabad, and they could successfully conduct court hearings while living in two different time zones for almost a month. A paradigm shift towards online dispute resolution, as we call it ODR, mechanisms has taken place in the field of arbitration and mediation as well. Digitalization has improved the efficiency of the arbitration process. It has helped prevent loss or damage to important records. The availability of digital records has also made enforcement of awards more efficient, reduced the burden of evidentiary challenges to court, and Indian courts have readjusted to modern times by offering an option of virtual hearings to lawyers and litigants. In the context of arbitration, this commitment ensures that it remains a reliable and preferred method of resolving commercial disputes in the digital era. In conclusion, we are about to delve into a subject that is both timely and timeless. India's evolving role in the realm of arbitration and mediation is not merely a professional endeavor, but a collective journey towards creating a world where justice is more readily accessible, more aligned with rapid pace of our globalization, and more reflective of our shared digital reality. Our conversations are to underscore the importance of embracing changes, not just through legislative reforms, but also practically. With a forward leaning legislative architecture, a judiciary committed to arbitration enforcement, and solid institutional underpinnings fortified by the rule of law, India is increasingly dismantling geographical boundaries through digital technology to facilitate online dispute resolution. This progress, friends, is a testament to the strength of our legal framework, our judiciary's dedication, our legal professionals' resilience and ingenuity. Undoubtedly, India stands as a reservoir of untapped potential, poised to ascend as a premier destination for commercial arbitration and mediation on the international platform. Here's hoping that India's persistent endeavor to harmonize its arbitration and mediation framework with global best practices will consolidate its emerging stature in the dispute resolution arena. Thank you all for your active participation and unwavering dedication to the cause. I look forward to some insightful contributions by the experts in the field in the oncoming working sessions. And let's now move forward with optimism and purpose, ready to make a difference to the lives of millions and showcase the power of effective, empathetic dispute resolution on the world stage. Thank you for your patience.
Thank you, Justice Kohli, for your insightful address and adding fresh perspective to our understanding on the topics under discussion today. Before moving on to the vote of thanks by Ms. Geeta Luthra, I have an announcement to make. I have just been told that the Indian Council of Arbitration will shortly conclude a memorandum of understanding with the High Court Bar Association and the Goa Chambers of Commerce for conducting Goa-seated arbitrations here. I now request Ms. Geeta Luthra to deliver the vote of thanks.
It is a pleasure to be here and to be giving the vote of thanks today in Goa. And I am trusting that all our fellow panelists will at least take off 2 days before, 2 days after, and enjoy the Goa spirit in the true style of a conference that is being held in Goa. So having said that, let me say good morning. Good morning to Justice Kohli, Honorable Judge, Supreme Court of India, who has extremely erudite, and we have had a extremely electrifying and inspiring session on arbitration. Let's hope we get into that spirit which is necessary for India. Honorable Justice Sunak, who we've been seeing as the face of the judiciary in Goa, and along with some very, very special judges here. But Justice Sunak has been ever pleasant and always here when we are here. Mr. N.G. Khetan, President ICA, again a bedrock for the Indian Council of Arbitration. Mr. Arun Chawla, Director General, and he is advisor ICA, is in fact, he is the bedrock behind the bedrock. So that's Mr. Chawla, Mr. Pereira, who's been a long-time flight friend whenever I'm traveling up and down to Goa. Thank you. Thank you all for being here. Thank you to the panelists. We have Ms. Anand, who's been Additional Solicitor General of India and who is extremely active. She was in Saudi Arabia. We had a recent conference of arbitration, and of course, Ms. Anand was there. Ms. Anand was there in Malaysia. Mr. Karya, we've just spoken about Mr. Karya, that he and Mr. Ganesh Chandru and Saraf and partners, three of the people who are the panelists, Priya Hingorani, who all of them are stalwarts, and we look forward to the 2 sessions that will be post-lunch. Now, before I start thanking the members of the introduction and today's opening statement, I want to say that Justice Kohli actually touched virtually every burning, smoldering subject in arbitration. Whether it be third-party funding, whether it be emergency arbitration, and how, even though we don't have a clause, and we hopefully will have a clause, we are at least enforcing awards with regard to emergency arbitration. We also are looking at other subjects in the Supreme Court as we currently speak. Section 29A, Rohan Builders versus Burger Paints. I think that's a case with regard to time period and extension of time, which is with the Supreme Court. Supreme Court has just decided on the unstamped agreement and various other aspects. So we can see that the courts are being extremely active and proactive with regard to disputes pertaining to arbitration, enforcement of arbitration, and Justice Kohli also spoke about an arbitration bar. Now, how do we get an arbitration bar? And if the same persons, if any person can be a lawyer, is the question then, can any person be a mediator or an arbitrator? And What stands between them becoming a good mediator or a good arbitrator is, according to me, training. But all of us think that we become lawyers, we've sort of achieved it all, or we've become judges, we've achieved it all, and nobody goes for training. So I believe that if we went for a little bit of training, whether informally or whether in sessions which are conducted by institutional arbitrations like the ICA, I believe all of us could be good arbitrators and good mediators. What you need is dedication. I also felt what was very welcome with Justice Chandrachud, the Chief Justice, said that let's make some young lawyers also arbitrators. But I also think again that some training has to go behind them because they do have more time and they may be able to deal with some cases a little more time effectively. What is most important in arbitration and mediation when there is a lot of heartburn, particularly in mediation, is we have to listen to the parties patiently. And one of the subjects today is about mediation, arbitration, whether it can be the same neutral, whether there should be different neutrals, whether arbitration, mediation should follow arbitration, or can it be arbitration, mediation, arbitration? How do you work this out? So that will be part and parcel of the next session. But as such, as Justice Sunak has said, we have to look at mediation, conciliation, arbitration, and we have to develop a temperament for it. So I think one of the aspects is a positive development of a culture and a temperament which will make us more amenable rather than when we've come on to the table, we really have hardened our stance. How to soften that? That's the task of a culture, and that's a task of mediation and arbitration, and we'll have to work on that. I must appreciate what also Justice Sunak said with regard to Lincoln's quote, and I enjoyed it. I perhaps didn't hear it very well, but I must say, was it that lawyers have to change from gladiators or predators to mediators? I thought both could be scary, and we should actually work at becoming good mediators. We don't want, while we want to be good lawyers, and while our duty is to serve, whether as mediators, arbitrators, or as lawyers, we do want it to make it possible that the person should remain solvent and not become insolvent. So, having said all that, I just want to thank each and every person, Mr. Pereira, Mr. N.G. Khitan, Justice Kohli, who's always been there for us, and a very, very special thank you to Justice Kohli. Thank you, Justice Sunak. Thank you to Mr. Arun Chawla and to everyone who is present here. Thank you so very much.
Thank you, ma'am. It is now time for lunch, and I request everybody to join us outside for the. Right.
the outset, I must thank the ICA, Mr. Ketan, Chawla, and Mrs. Kohli to be here and give us the privilege of having this first conference in Goa. I must, when I interacted with Mr. Chawla and Mr. Ketan, I requested him that we should cooperate because really in Goa, we have difficulty in getting good arbitrators. We have, we have to resort ourselves to retired judges. When I took over as the president of the association, I struggled with Mr. Sunak because I had to, Mr. Sunak to depend on the establishment at the headquarters of Bombay High Court to have some lawyers designated as arbitrators. And I could get the Bombay High Court to have them on the panel of arbitrators. But still, we need to do more. We need training in arbitration because it's a new field to Goa. Goa has started coming out, getting into a system of commercial arbitration recently. So therefore, I requested Mr. Chawla, with the same in mind, to have some training courses for us, for lawyers here, and have more interactive sessions for arbitration and conciliation, which we are now relegated only to the Legal Services Authority, which is becoming a little mechanical. There is no interest. But if the arbitrators who are dealing with private arbitrations are involved in this, so with this aim in mind, looking at the state need, I am thankful to Mr. Ketan and Mr. Chawla for having agreed to join us in this pursuit. Thank you.
Slight change in the program. We'll be taking the second technical session first, which is on the topic Holistic Dispute Resolution, MED-ARB or ARB-MED-ARB. This session will be moderated by Ms. Geeta Luthra, Senior Advocate, and she's joined by three very renowned legal practitioners. Mr. Sanjeev Kumar Sharma, Senior Partner, Saraf and Partners. With over 2.5 decades of experience, he is known for advising global companies in dispute resolution. Based on his experience and versatility, he was appointed by O.P. Jindal Global University as Honorary Adjunct Professor of Law and Professor of Corporate Legal Practice in 2020. We have with us Ms. Priya Hingurani, Senior Advocate who has been in active legal practice since 1990. Her primary area of practice is Supreme Court of India. She is not only a successful lawyer, but also a women's rights activist and regularly speaks on practical aspects of law concerning women. We are also joined by Mr. Gaurish Agni, Advocate and Secretary, Goa High Court Bar Association. He is an independent legal practitioner with over 2 decades of experience. He practices in a variety of legal fields and is famous for his lectures at V.M. Salgaonkar College of Law and active participation in the lawyers' fraternity. Over to you, Geeta ma'am.
Hello, hello. Good afternoon, everyone. Now, most important, we've to make this interesting because this is the post-lunch session. All of you are well satiated and maybe slightly oversatiated. We are in Goa. So we have to make this interesting for you so that you sit up and you are ready to ask questions in the last 20 minutes that we will have. I want to start by saying something very controversial in arbitration, and that's somebody from Singapore, and I'm not naming that the arbitrator, but he said mediation, arbitration, or mediation, arbitration, mediation by the same neutral is actually poisonous and toxic. So he called it toxic. That's a very strong word. Now we have to see from the Indian ethos, from the English law, common law ethos, where we keep saying that there should be impartiality of the judge, impartiality of the arbitrator. There should not only be bias, there should not be a seemingly even an apprehension of bias. What happens when the same person is given a hat of a judge and a mediator? Many judges will say to you that, look, because I'm adjudicating this matter, I don't want to be a mediator in the matter. I don't want to be calling the parties to chambers and deciding because I may get biased. Now the question here is it toxic? Because Singapore and Hong Kong seem to be saying, same person wearing the hat, there's nothing wrong. There are other jurisdictions which say, no, it's a complete no-no. You cannot have the same person first as a mediator listening to my secrets, knowing that my secrets will never be disclosed to the other party, my weaknesses will never be disclosed. And suddenly you have that person as an arbitrator because his mind can't change. The knowledge that has already come to him won't go away. It won't be blown away. So what do you do? How do you decide this anomaly that there should be the same person wearing the hat, there should be two different persons wearing the hat, there should be a disclosure of whatever you've learned as a mediator to the other side if mediation fails. Or Japan says, in that case, have a written document saying, yes, we are agreeable to go to arbitration. Or where the midpoint can be, we agree to go to arbitration to the same neutral, but we take it in writing that, look, you don't feel there'll be a bias. Only then go to that person and then go to, otherwise, go to another person. The other thing, and this is the elephant in the room, which none of us really managed to find a solution to, the costs of arbitration. So while we think arbitration is effective, it's fast, it's commercially viable, foreign investors will want to invest in India because India will have a great arbitration regime. We are getting scared of the costs involved in arbitration. How do you restrict that? And do you then say, look, I'll go for mediation and then go to court? Because there are cases of huge amounts which are coming where the arbitrations are very hefty, and the panel, there's none better than this panel to advise and to suggest that, is it really happening that people are going, right, echo coming, that people will say, if it's worth 200 crores, I'll go to arbitration. But if it's 5,000 crores, I will go to a court of law because arbitration is becoming prohibitive and is not being time effective. So we have to think, because our arbitration era is just on the threshold in India. We have to make sure that what's wrong with it is nipped in the bud so that we can be serious arbitrators and serious arbitration lawyers. So the question I am going to ask my colleagues, almost the same questions, and I will start with asking Priya whether, what does she think, should mediation, arbitration, or should it be arbitration, mediation, arbitration, and whether it should be the same neutral. And then I'll ask the same question to my colleagues on my right.
Thank you, Geeta ji. Good afternoon, everyone. Um, as a mediator, I'm a trained mediator, so I have a little bias towards mediation. And my experience in this last 3 decades has been that mediation is just starting. It's taking its baby steps in India, particularly. Whereas arbitration has been here, of course, we used to have community mediation, panchayats, lok adalats. We have had those forms of mediations or, conciliations or ADR forms. But mediation per se in India has taken off in the last decade, and it is now being called the need of the hour, particularly in certain sections of disputes. So I would personally vouch for mediation and arbitration. Definitely, I would say in all the contracts, in all the agreements that we have, pre-litigation mediation must be a clause in that. And of course, arbitration is always a clause, most often is a clause in all these agreements that we see. Because as it's been mentioned, mediation is a tool or is a situation where it's a win-win situation for all. It's it is by consent. Mediation is where the parties are comfortable with each other. And very often in commercial matters and commercial dealings, we see that the parties do want to continue to have that relationship. Somehow the relationship gets off the track because of some dispute. And you find particularly the smaller vendors or the smaller stakeholders, they want to, continue to have dealings with that particular party, but they don't know how to go about it. They feel if we go into litigation, the tie will break completely. If you go into arbitration, there'll be a decision one way or the other. So mediation, they find, is a way where they can resolve their disputes and continue to have that business relationship with them. So we found in many of the matters that we've done that mediation is something which people are now looking at. A question is of creating awareness. Question is of sharing the importance of mediation with people in the commercial area. Also, now with the Mediation Act having come in, it is important for us to understand, because of course there are just two aspects of the mediation bill which have been notified. There's still a lot of work. The rules have to come into force, have to be made. Issues of ethics, issue of kind of training, everything all needs to put in place. At the moment it's not being done. The second aspect is that when you look at arbitration, mediation, arbitration, that I think has not taken off in India as much as MED-ARB is being thought of. It's very difficult for, I think, parties to understand the concept that if you're fighting with each other and filing claims and counterclaims in arbitrations, to suddenly feel that they can go and discuss some aspects of it in mediation. Also, we find that the arbitrators per se are not interested in mediation. I mean, to be very frank about it, when you find sole arbitrators particularly, if you're a panel of arbitrators, I think the arbitral tribunal does still, think about sending certain issues. But we looked at sole arbitrators, they feel that, if the matter goes into mediation and gets settled, they would lose their, fee, professional fee.
I'll just come back to you on the next question, but in the meantime, I wanted to pose the same question to Sanjeev, who's senior partner in Saraf and Company and has a long history of being in arbitration and in the center of the most controversial cases where every lawyer would want to be in arbitration. I want to ask him the same question because, as Priya said, MED-ARB-MED has not really taken off in India. Now, is it a good idea? And would there be a breach of confidentiality? This is one question to you. And the second one is also what Priya touched upon, the Commercial Courts Act and the now mediation being a necessary tool of it. How good do you think is this? Thank you.
Thank you, ICA and Geeta ma'am, to have me here. I will try to answer all these questions sequentially. First of all, I think the issue, when we talk of mediation, there are two very important issues which we need to consider. The first is the impartiality and neutrality, and the second is about the enforceability. We'll come to enforceability later on, but first is very important. Ma'am started with saying that there was a lawyer in Singapore who says that neutrality is something which is sort of a toxic thing. I would not use a very strong word like toxic, but I would say that it's a very sensitive issue. Neutrality and impartiality is something which is very important. And I think parties also feel that, yes, if a mediator and if they have to move to arbitration, neutrality of arbitrator is something which is very, very important. And that's why I think the Mediation Act of 2023, of which I think most of the sections are required to be notified. In section 17, it says that a mediator can't be an arbitrator. So even the Indian law recognizes this fact that neutrality is something which is actually the foundation of having a very effective mediation. Then we'll come to enforceability. But by way of background, when we talk of mediation and arbitration, obviously there could be very different forms. It could be in different forms that there could be two mediators. One would perform the mediation role, other would perform the arbitration if it is required. So there is one protocol which is Singapore protocol, which is called Arbitration, Mediation and Arbitration Protocol of 2014, and it also basically acknowledges the neutrality concept as a very important concept to have. So what is the process there? Obviously, in India, this is yet to be implemented. So let me in fact give you a background, but because if you want to have that kind of a forum, that kind of a process, you need to have that kind of an arbitration agreement in a contract. So what is there? So once you have a particular kind of a contract or arbitration clause in an agreement, which acknowledges the requirement of mediation also, and if you go to Singapore International Arbitration Center, they would they would ask the parties to issue an arbitration notice. They will constitute a tribunal. And immediately after the constitution of the tribunal, they refer the parties to the Singapore International Mediation Center for Mediation, where you have a neutral mediators to mediate. Once the mediation happens and there is a settlement, the settlement agreement comes back to the Singapore Arbitration Center and is placed before the tribunal so that it can be enforced as an award or it can be passed as an award, which becomes very easy to enforce because otherwise standalone mediation agreement are generally treated as contracts. So they are not, but yes, let me in fact clarify also, Indian Mediation Act in section 27 acknowledges that if there is a mediation agreement and there is a settlement because of that, then that will be treated as a decree which becomes enforceable. But that is yet to be notified. So I believe so. I think neutrality is something which is very, very important to have, and I think this is something which has been acknowledged by Indian legislators also, under Indian law also, and in fact in foreign. In fact, there is one convention 2019 of Singapore on mediation, where only 13 countries in the world have signed so far. India is not a signatory, which also acknowledges the same concept. So I think neutrality is something which is very important.
Now coming to you, Mr. Agni. Mr. Agni is, as has been introduced, is the person who will tell us and give us the answers with a slightly Goan flavor, I hope. So, so we are asking you the same questions. Do you think, and that's the way many laws in India seem to be going, that mediation is now mandatory and it's not just. Is there any negativity in making mediation mandatory? How does it affect urgent reliefs which a party may be wanting? And do you think that the arbitrator, like in Singapore and Hong Kong, where I haven't heard any allegations against the arbitration mediation if they are a common person, same man wearing different hats. Do you think we can possibly in India have the environment to have the same person wearing a hat of a mediator and an arbitrator, or will it militate against the impartiality of the process? Thank you.
To continue with what the other two panelists have stated, I was doing some reading on this mediation, arbitration in terms of the international perspective. And the Mediation Act 2023, which India is now looking at, I think it is founded more on the principles which were set out in the American mediation law and the code of ethics which is there. Traditionally, Singapore has been always been a little different as compared to the West. And Singapore and China believe in having the same person act as mediator and arbitrator. But in the US, the Arbitration Uniform Mediation Act and the Arbitration Code of Ethics, which is there, which is followed in Texas, in Ohio, we find that there are specific clauses that the arbitrator and mediator will not be one and the same person. And there is a clear requirement of neutrality, confidentiality, and not passing over of information. In fact, those laws say that once an information comes to the mediator's hand, that information should not be let out by the mediator at any cost, and that confidentiality has to be maintained, because concept of equality is what is founded under the ancestral model of law. So that's the basis. Now, statistics also say that if the arbitrator and mediator is one and the same person, however much the mediator may try or the arbitrator may try to detach itself of the dual role, ultimately it's the human fickle mind. That's how they have read the concept. That as a mediator, you collect information from parties, and let us understand mediation and arbitration. Arbitration is a rigorous legal process, though it was meant to simplify us out from the civil courts. And mediation is something which is voluntary and which parties look to at a more conducive environment. So maybe in an arbitration, you will hold all your cards close to your chest and place them in the proceedings as and when the proceedings progress, the stages in an arbitration come. But before a mediator, you may open up all your cards knowing that the mediator is somebody, a neutral person. There is a confidentiality, there is a more conducive environment. And you may even disclose things which you would otherwise not disclose to the arbitrator unless it's legally strategized. So considering that, when information is given to the mediator, to use the same information or not to use is something which is purely individualistic and it has a human element. And statistics has it that though Singapore model has been time tested, by and large, the arbitrator and mediator has not been able to distinguish duality of role. And the human element of having acquired certain knowledge does come into the proceedings and may have the effect on the ultimate outcome of the matter. Because there have been instances internationally where parties have gone into mediation, arbitration, mediation, and arbitration, ARB-MED-ARB. And when the arbitration was broken down and stopped and mediation was initiated, when this information was gathered, and there are even legislations that if this sort of a mediation fails, there can be forced arbitral award or a forced mediated award. So that principle has come in. Now, coming to second part of your question, ma'am, Mediation Act 2023, I think is a great step in this regard. Because as Sir has rightly said, the Mediation Act clearly says a mediator cannot be an arbitrator. And the check and balance in the Act is the same like the Arbitration Act. Because just as the arbitrator is supposed to disclose his impartiality or any adverse interest in the matter, this Mediation Act also requires the mediator to disclose any conflict of interest before he engages as a mediator. So the Act itself has an inherent neutrality and a check on neutrality. So therefore, I think neutrality is very much important. And following Singapore model of law in India may be a little difficult considering the democratic and the vibrant setup that we have and the demographics and the mindset of the people. So my opinion is that there should be distinct roles of a mediator and arbitrator and not combined.
So, coming to a question which may be slightly different, what do you think is the hat of a mediator and what is the hat of an arbitrator? And tell me why in this process would you think that mediations are not, arbitrations one way or the other will result in an award. A mediation may result in success or failure. What are the roles that you would see a mediator has to play, which is different from an arbitrator? And why do you feel so many mediations in India as compared to, say, Singapore or even in the US are unsuccessful?
Uh, I would rate it largely to the understanding of the parties that mediation has no real backing of law unless it is a statutory mediation or an agreed mediation or it's an institutional mediation. Because this is where the consent of parties comes into picture, and consent comes with its risk. So if it is voluntary mediation, the chances of success will depend on the active role of the mediator in pushing the parties to a result, and it's equally to the will of the parties to give and take and be agreeable to arriving at a resolution of the dispute. What happens in arbitration, as we all know, you are very sure that the end of it, there is always going to be a result, whichever way you contest it. In mediation, you are aware that unless it is imposed mediation, imposed in the sense it's statutory, like in maybe a commercial code sec where there is a requirement to mediate before it is a specified value, or like if this mediation act comes into picture, there's an agreement in which there is a mediation clause and you agree to be bound by the mediation, and as sir said, the act says that it can eventually be enforced as a decree. It's only when that there is a feeling that this will be enforced, then the success rate of mediation will go up. Uh, you had also asked me what is the trend in Goa. In Goa, we find a lot of matters which are referred for mediation, and they are typically matrimonial disputes, they are custody matters, they are matters which are family disputes, or they are neighborly disputes like right of way, excesses, easements, etc. These are matters where our courts have been taking active role in Goa and have been pushing parties to mediate. And the beauty of it is, at least in my little experience that I have at the bar, I have not seen the judge act as a mediator himself, except for in custody matters, where the judge has played a limited role of trying to interview the parties and understand what the dispute is and not travel beyond that. Moment the court has done a preliminary interview and found that parties may be willing to go for a detailed discussion and resolution, the trend in Goa is the judge refers it to another judge for mediation and to submit a mediation report. Similarly, even at the High Court, we found our judges playing a very proactive role in such type of disputes, being referred to trained mediators and asking an independent mediator to submit a report. And in many cases of typically this nature, we found that the success rate in Goa is quite high. In commercial disputes, it is always something which is asking mediations.
Uh, Next question to you, Sanjeev. Uh, with, while maintaining anonymity, can you tell us any interesting cases where you have participated as a lawyer or as an arbitrator and which have got mediated and resolved? Are there any such cases, or does this not happen?
In fact, because the kind of work we do, these are commercial high-stake disputes. A lot of settlements have happened, not because of mediation. But I'll just tell you, in fact, over a period of last 15, 20 years, the mediation has also matured. I think you are here and my senior colleague, Ms. Anand is here. They would understand, they would acknowledge also that 15, 20 years back, when the mediation was gaining ground, it was because of the litigation fatigue the parties were referred for mediation. They will say, now you have fought for 15 years, you have fought for like 10 years. Please try mediation also so that you can have some sort of a settlement if there is any possibility. From there to travel to now, a situation where the Commercial Court Act says that if there is a dispute above 3 lakhs, there has to be a mandatory mediation attempt. Obviously, most of the time it fails, and then ultimately you are before the court. In commercial disputes, as per my experience, a lot of settlements have happened. A lot of settlements have happened because of the futility of litigating on certain technical and challenging commercial disputes, not because of the litigation fatigue, because you know most of the companies have very deep pockets, but not because of the mediation as such, but because of the will of the parties. They try to settle it out to the court and come to the tribunal to pass a consent award.
So
But
my question to you is, have the arbitrators played a nudging role or not? Have their contribution been major in the settlements, or have you simply done it outside without the arbitrators helping you or pushing you, giving you a gentle push?
so their contribution, I believe, I think, is very important to the extent that if they are at the advanced stage of the arbitration, they acknowledge that if parties can settle it, there are other reasons also. I do not want to dwell why they are always interested in settling before passing an award. But yes, they always encourage parties to settle it, and they say that yes, if you can settle it outside, better you do it, because we know inside and out of the matter. We may be biased because of certain legal issues, but they try to avoid being the mediator in the arbitrations, ongoing arbitrations. So they ask the parties, if there is a possibility of settlement, you go out, you take few days out, and then try to settle it, come back with an agreement, we'll pass an award based on that. So they avoid being the mediator as well as the arbitrator.
Priya, last word to you. Before we open it to the House for some questions, if they want any. Do you feel as a mediator, the persona of the mediator or the persuasiveness of a mediator goes a long way to helping settle matters? And what is it about a mediator that gives that extra nudge? Oh, so and so is a good mediator. Let's get so and so appointed. Let's get Priya appointed. What happens? How does it happen?
Absolutely correct, Geeta ji, that the person, I think first of all is the training. It's very, very important to have trained mediators in commercial disputes. Training is a very important aspect. The persona, yes, the persuasive skills, and they all come with training and years of experience. I know of so many commercial matters which get settled at the Delhi High Court Mediation Center or at the Supreme Court Mediation Center. And it's also because there are a lot of mediators who have specialized only in commercial, maybe arbitration and commercial matters in litigation, that because they also have become mediators and are with the mediation centers, that most often commercial suits are sent to them because they have the background, the knowledge, and the experience. And once they make the parties very comfortable and the parties feel that they can confide in the person, very often we find that they will give on the sidelines in the caucus, in the separate sessions, that, you know, this is our benchmark. This is the highest amount we would want, and this is the lowest we are willing to settle for. So that kind of confidence when they have in the mediator to give a benchmark on what is their maximum and what is their minimum helps the mediator also to kind of negotiate, facilitate the mediation. So it's very important, as of course it's voluntary, but I think even commercial suits, a lot of parties are definitely wanting to go in for mediation because they find the arbitration to a very expensive process. On the one other point which I want to say is that, you know, we most often have arbitrators, the arbitral tribunal, as former judges who are not trained mediators, or they have, of course, you know, dealt with mediation at some point or the other in their judicial career or as the legal career. So it's, you know, the difference between a seasoned and you know, a arbitrator, a former judge, and a trained mediator is huge. So when we talk of MED-ARB, I think it's so important that if you're going to a trained mediator and you're going to try pre-litigation mediation, or even if not pre-litigation mediation, which is mandatory as per the Commercial Act, I find a lot of matters do get settled there. It's my experience.
Thank you. Now to the House. Does anyone have questions? If they can stand up, ask the question, and tell me who it's addressed to then, and introduce themselves and tell me who they want to ask the question of. It's would be very welcome. Yes, yes. The mic's just coming to you. Just introduce yourself and ask the
Hello,
question.
good evening, everybody. I'm Arun Pandey. I'm an advocate from Goa. I handle basically corporate mediation. My experience is that we have in India, we have lawyers who are litigators, and I mean we have been finding it very difficult for the lawyers who are handling litigation to advise their party to go for mediation. So I would like to ask Mr. Sanjeev, how difficult or how easy it would be for, like in America, the experience is 50% are litigating lawyers, they are mediators as well. In India, the percentage will be negligible. So how easy or how difficult it would be for a litigant lawyer to go into or migrate to mediation?
See, if you ask me to answer this very objectively, it is very difficult because it's a very subjective question. It all depends on the lawyer to lawyer. But if you ask my personal, I always advise whenever a client comes to me, if there is any possibility, better settle. Because if you can gain some money immediately right now, because you know the kind of processes we have, whether we are talking about the arbitration or whether we are talking about a normal general suit, a recovery suit, or any other suit which you have to file before a court of law. Ultimately, there are different challenges which you have to overcome, and then the recovery, execution in itself. I'm being part of a very big litigation where execution is pending for such a long period of time, and there is a recovery to be made of 5,000 crore by a party which is not an Indian entity. I would not name that litigation, but I am being a part. Now the endeavor at this stage is that they want whatever they can recover, they want to recover. What from wherever, whichever party they want to settle, they want to settle it, so that at least they can have some recovery out of it. So it's always my endeavor to suggest to the client that yes, if you can settle reasonably, I would not ask you to take a long or deep haircut, but yes, if you can get a reasonable amount, if you can have all the issues settled in a very reasonable manner, because what we face are different types of, not just the recovery, but there are issues which are related to intangible assets, related to like trademark. There are different other issues also, use of trademarks and copyrights. So if you can settle and just overcome and just focus on your business, because ultimately what you feel, what even the companies feel and individuals especially feel, that cost on litigation is unproductive. They just pay it because they have to pay. Otherwise, for them, I think it's always, if they hear it from their lawyers, they always come, they say a lawyer would definitely advise them to litigate and see. But if there is an advice from the advocate that please settle if it is possibility, then you are a lawyer for that client for the life. I think this is, yeah, this is something which I feel.
Any other question?
Hello, my name is Vikrant. My question is to Priya Madam. I am practicing in commercial matters and some matrimonial matters, some criminal, quasi-criminal matters. Whenever I try to convince the parties to come for mediation, there are many matters which we personally feel the court will take years to decide, or mediation is the best thing in those matters. But parties are looking for something like sanctity in those mediators, which is available with the courts. I mean, they don't trust the mediators as much as they trust the courts. So, how do we convince the parties to come to mediation, or how do we make them believe the mediation process?
Yeah, you're absolutely right. There are a lot of litigants who have more faith in the courts, and they're willing to take their chance in court, however long it takes, rather than going in for mediation. But it's See, the thing is, we have to explain to them, and I think the honorable courts also do their bit in telling the parties to go in for mediation. Some litigants, unless they have litigation fatigue, they are not willing to go into mediation at all. So sometimes you have to wait for the right time. But by and large, we find if the courts put a little pressure, if they're not willing to listen to the lawyer, the courts do put a little pressure and say, go in for mediation. In fact, in Delhi and northern region, we find some of the judges, if there are particularly matrimonial matters, as was mentioned, or custody matters, and sometimes family disputes, sometimes the judges call them in their chambers and try and mediate between the parties as well, in a sense that they try and understand where the hitch is, why are they not going in for mediation. They don't do mediation per se, but they try and understand why they don't want to go in for mediation. The other reason, I think it's very important, private mediations are taking place. We have a lot of law firms across the country who have mediation law firms which have come up, not so prominent as they are established in other jurisdictions. But when you're talking of court annexed mediation, a lot of sanctity is attributed to that. So you should try and them to go to the either mediation center in the district court or the high court, so that they feel that the sanctity of the process is there.
Yeah, please. Can you give the mic?
Hello. I hope it is not only the asking of the question, but can I share my experience on whatever discussion is going on here?
I thought if you can put it shortly, it's really for
Yes,
questions. But if
because
we can,
we are
in brief, in 1 or 2 minutes,
Yes.
have your view.
I am Advocate Anurag Jain from Bombay High Court. I am also an impaneled arbitrator and mediator of Bombay High Court. We were talking about donning the hat of a mediator and an arbitrator. But in Arbitration Act, even there is a provision under Section 30 that a tribunal can mediate between the parties. And I have successfully handled that in 3 disputes where the parties agreed on settlement, not objected by the other party, and time was cut short, costs of arbitrations were cut short, and it happened in the award. Same thing is in the mediation. Now that Mediation Act has come and Commercial Courts Act has come. 3 disputes were referred before a commercial court acknowledges it as a suit. And those were settled because you have to impress on the parties and give them confidence that it would be an effective resolution of their dispute. Otherwise, going in the courts and taking longer time, which is the main aim as the mediation. So that has been happening. But you have to impose the confidence in the parties that it would act as an effective settlement. That only I wanted to share.
Thank you. Thank you. There was somebody who had a question there. You, yes, the lady here.
Good afternoon to the panelists. My question is open to all the panelists, whoever feels to answer. This is Jui Salarka. I'm an advocate by profession and the founding partner of Modern Unified Dispute Resolution Access. My question is, does financial incentives usually influence the arbitrators to take arbitration and not mediation? Because it's arbitrators' decision versus the mediator's facilitation.
So first, may I ask Mr. Agni to answer, and then everybody else can.
Yes, because one more thing, because then why won't an arbitrator just tell that why do I want to conduct mediation? I can directly conduct arbitration, or a mediator can just say that I can just be a mediator, not an arbitrator. Why is the term coming out together as mediation, arbitration, med-arb, or ARB-MED-ARB, like that? Thank you.
In India, most of the arbitrations you see are appointed arbitrators. In the sense they are either named in the agreement or there's an application moved to the designated court for appointment of arbitrator. So the arbitration fees normally would come into picture once the arbitrator is appointed. So arbitrator at the inception is not driven to accept an arbitration looking at the fees, etc. It's just a consent taken on the basis of any conflict of interest or no. Mediation again it's not that mediators are not paid. When a mediator is appointed by the court to mediate, the mediation fees are again fixed in terms of the mediation panel and whatever mediation structure under the legal services, etc. So I do not think that being engaged as a mediator or an arbitrator is per se driven by the economics. Okay. And the second part of your question was mediation, arbitration, or arbitration, mediation, arbitration. Now, they are fundamentally two different concepts. Mediation, arbitration would be where you initially engage into mediation, and in the event the mediation fails, then you either look at going into arbitration if there's an arbitration clause, or you would be relegated to a regular civil remedy. Now, if you look at some countries, like even in Australia, there is a procedure of pre-litigation mediation. And in that pre-litigation mediation, you have a lot of your claims which are discussed in advance, where there are attorneys on either side, there are parties on either side. They share their claims, they share their documents. And in that sitting, in fact, there is a provision even in under our civil law, under CPC, for admission denial of documents, which is very seldom pressed into service. But in many foreign countries, this is a very important step which is taken before you actually go to the courts. So in this pre-litigation mediation, this step is given vital or a pivotal role, where you are called upon to admit and deny a claim as well as admit and deny documents. And it is only that part which is not admitted and which is in dispute, which will then go for arbitration or will then go to a regular court of law for adjudication. So look at the amount of process that is cut short. And what is agreed upon in pre-litigation mediation is documented, is reported, and is part of the regular litigation tomorrow, and which cannot be contested. So if that is mediation, arbitration for you. But once an arbitration is initiated, it is after initiation of arbitration, either the arbitrator feels that you need to go for mediation, or parties may say that we want to explore mediation. As Sir said, looking at either the time expense or the fact that the cost of litigation might be much more than preferring to go for mediation. So that is called, typically in our legal term, it is called the mediation window. So that's, or the break window. That is the period when parties say that we want to stall the litigation for a moment and look at mediation. Now, why a lot of parties don't look at doing that is, in India, our litigation comes to a standstill moment parties are referred for mediation. The litigation does not continue parallelly. In foreign systems, your process of litigation will continue parallel to mediation. Therefore, ARB-MED-ARB is a success maybe in foreign countries as compared to India. So here, if parallelly the process can go on, then definitely mediation and arbitration could be a success. And it's again on the will of the parties. So I hope I've answered your question.
So if I may, can we have, all right, Manoj, you ask the last question and then I'll sum up. We have 3 minutes. Oh, yes, yes, please. Yes, please.
Yes, I am from Nagpur. I am working as a civil engineer. So my question, you can refer that question to any of the panelists. In Arbitration Act, the formation of council process is going on, what I know. And the Mediation Act also, there is a provision for formation of council. Whether these two councils can be a one council, because by and large, their motto or their, that is the same motto. That is the resolving the commercial dispute. So and why it is so delaying? From last 4 years, the council has not gone so forward or taken the steps required.
So if I may just say this, that in mediation and arbitration, very frequently you will see a different stream of mediators and a different stream of arbitrators. The question which comes in this MED-ARB-MED is, should you have one single stream? Now, it is possible. I mean, it is possible. The question again then is exploring this whole aspect that do you want a single neutral or do you want two neutrals? You may have one counsel, but you will have one doing the mediation. When mediation has failed, another person takes over. So, this is something which is in fact the subject of debate today, that should you actually be giving it to two different neutrals, whether you have one body for arbitration and the same body for mediation is something which cannot be faulted as long as they are trained in both. But because you have to be trained separately for arbitration and separately for mediation. Manoj, will you ask your question and then we'll wind up?
Can I just add on to what you
Yes,
just said?
of course, of course.
See, the important thing is that it all depends on the construct of the arbitration agreement. If the parties have agreed that there would be different tier of arbitration or dispute resolution, one is the mediation, other one would be the arbitration, and the parties are basically fundamentally agreed that one person could mediate as well as arbitrate. There is no harm. So both the processes have pros and cons of its own. But just to tell you, the Mediation Act 2023 is fundamentally making a difference. It is very clearly in section 17 saying that a mediator can't be an arbitrator. So neutrality and impartiality is something which is being taken very seriously in India also. I have given you the example of Singapore also, where there is Singapore Protocol of 2014, where Singapore International Arbitration Center as well as Singapore International Mediation Center, they have come together to create that kind of a protocol where if the parties have agreed to go through this mediation and arbitration process, they can approach Singapore International Arbitration Center, who would constitute a tribunal first, and then hold the process there, send the parties for mediation. If there is a settlement, that agreement comes back, and it will be given a shape of an award so that it can be enforced. So it will be like a very speedy dispensation of justice and adjudication of the disputes.
Thank you, Geeta Luthra ma'am, giving me opportunity. I'm from Uttarakhand, but practicing lawyer in Supreme Court last 22 years. I got opportunity to handle mostly arbitration matter. There are lots of difficulties. And one humble submission I'm requesting through ICA. When there are lots of matters pending in Nainital High Court and different other High Court, the difficulty is we are in panel of the appointing arbitrator, but the judges, they appoint any arbitrator, and this is the questioning of the entire of the bar association discussing. We are from Nainital High Court, we are from Chhattisgarh High Court, we are from this High Court, Jharkhand High Court, but because of judges, they all are engaging any arbitrator for other states, and this gossiping around the entire of the
See,
all
ask
High
your
Court.
question. We don't want to hear this. Ask your question. This you can discuss over tea. And this was the last question because the next panel has to be. I'm glad you've asked the question. You've made us all wake up. But now we have to go on for the next question. Regarding what you are saying, there are quotes and quotes. I know one of the Bombay High Courts was in the last conference, told me that as a matter of practice, she appoints lawyers, including young, including old lawyers, because she feels that they have more time and they will do it quickly and very efficiently. So we cannot say that somebody appoints anybody or not. Sometimes it's because of stature, sometimes it's neutrality, whatever be the reason. The fact is that here we are trying to keep the subject to MED-ARB-MED. And I think all my colleagues agree that we are all wanting neutrality to be maintained, and therefore it should not be the same person who should be wearing the hat of arbitrator, mediator, and arbitrator once again, but different persons for the sake of neutrality, for the sake of transparency, all of which we hold very dear. Thank you, all of you,
There could
for
be
being
one,
here.
sorry, I'm interrupting. There could be one solution to his problem.
All right, tell.
So there is, you know, that there is a concept of discretion of the judges. And obviously they use their discretion to appoint the arbitrators. But if you want to overcome that, you can have a, just like Delhi has an arbitration center, you can have your own arbitration center where all the lawyers can become arbitrators. And obviously once the parties have that clause in their arbitration agreement where they follow the rules of the Nainital Arbitration Center, the court has no jurisdiction to appoint an arbitrator. So Section 11 would not be filed before the court. Because if you are following an institutional rule, the appointment would be in terms of those rules. So the discretion is out. So that's the solution which you can basically think of. Thank you so much.
Thank you for the very clear, specific, precise observations which have been given by the panelists. Thank you so much. We will now be moving on to the next and the last technical session for today, which is on the theme Evolving Landscape of Dispute Resolution and Effective Use of Technology in ADR Mechanism. Ma'am, please, there's a photograph for everybody. This session will be moderated by Ms. Pinky Anand, Senior Advocate and former Additional Solicitor General of India. She is an internationally recognized arbitrator, a published author, and a renowned private international law expert. Joining her, we have Mr. Tejas Karya, partner and head of arbitration practice at Shardul Amarchand Mangaldas. He has advised on amendments in the Indian arbitration law and has backed Joining us in the panel, we have Mr. Tejas Karya, partner and head of arbitration practice at Shardul Amarchand Mangaldas. He has advised on amendments in the Indian arbitration law and has bagged several awards and recognition for his stellar work in commercial arbitration. We have Mr. Ganesh Chandru, partner, Dua Associates. In his practice, he handles cases arising from transactions relating to oil and gas, infrastructure projects, and construction, amongst other areas. His practice includes advising and representing parties in international arbitration matters. He has earned several accolades, with the latest one being Capital Foundation's Arun Jaitley Award for the year 2020. We also have with us Ms. Mumtaz Bhalla, who is a partner in the arbitration, litigation, and dispute resolution practice of ELP law firm. She is an advocate on record with the Supreme Court of India. Ms. Bhalla has over 15 years of experience in the field of litigation and dispute resolution. She specializes in domestic and international arbitration and has featured in the Forbes list of India's top 100 lawyers. Handing over to you, Ma'am.
Thank you so much. So, ladies and gentlemen, I think the plan for this panel was I would give some short openings remarks. I hope they will keep us alert and electrified, as my colleague used the word earlier. And we'll go on to some questions between the panelists. But really speaking, in fact, the subject of this panel is an interesting one. We've dealt with MED-ARB-MED in the earlier one. Some mention has been made of artificial intelligence, but that indeed is one of the focuses of this panel, the primary focus, so to say. So the evolving landscape of dispute resolution and effective use of technology in ADR mechanism. Now, most of us are not really, I don't think so. So correct me if I'm wrong. So most of us are not AI experts. We are lawyers principally. Some of us have adapted, and some of us want to adapt even more. And that is the broad direction that we are talking about in this great environment of ADR mechanism in India and today in Goa, and hopefully with the Goa Center for Arbitration coming up as we speak. We are on the threshold of that movement. But indeed, use of AI itself is embedded with a lot of questions. There's a positive side, of course, and there's a negative to it. So when I was looking at the subject, I said, which way should one really proceed? What is our thought on it? So nobody will say don't use artificial intelligence. But some of us will say that there are problems with it. And finally, possibly the net result that would come is use it effectively with certain controls, certain thoughts in the process. So while talking, I just want to go back a couple of thoughts here again. I looked at artificial intelligence in law, not only in ADR, in the broad field, in yesteryears of some 80s, when there were programs and software like SEC Online, LexisNexis, Manu Patra, etc., which came around. So I saw some program called Orion in USA, and it started in 80s. And these went on to progress. In fact, we were asked to do a program similar to this, and we tried initially, but everybody wanted textbooks those days. So talk about artificial intelligence. These softwares have come today to being. Books are getting, to some extent, put on the back burner. They're not gone. But yes, we have come to a time where we have all adapted ourselves to using the software, using iPads, using these programs and technology towards this entire effectiveness. So that is a world which you have come to. You've come to Uber. You've started using apps. You've come to Amazon. Each of these are artificial intelligence mechanisms, and we all know the answers. Basically, they are efficiency, they are cost effective, time effective, and they tend to promote, of course, primarily a time efficiency and an analytical skill, which really goes there. So I'll just go back to a broader subject for a moment and come back to artificial intelligence. The effective use of dispute resolution. You've heard from the morning some parts of where we are today, and India indeed has become a forerunner in the field of arbitration and ADR resolution. So three quick points here, and our panelists will address in some detail. So three things that have identified India in the recent past is the pro-enforcement mechanism that we are adopting. So, for example, the latest being Vijay Karya, which talks about pro-enforcement bias and minimizing the issues that relate to challenges. And there are many more of those judgments. You have the issue of Cox and King, which has come around to adapting the group of companies doctrine, which allows companies to be governed even though formally they are not parties to the arbitration agreement. And incidentally, that will lead a long way, and I'm sure Tejas and others will contribute to this, towards the international arbitration that is prevailing in the field. And possibly the third, which is very important, which has just recently come, is NN Global, which not only talks about unstamped agreements being curable, but the essence of saying uphold arbitrability, uphold in favor of arbitration. So the ADR mechanism which goes into place, and this might put something to rest. As far as the AI is concerned, so I was looking through three things. One, the AI in India has gone up tremendously. It has gone up to almost 76% rise, about a 3x rise from 2020 till 2022, which is a phenomenal increase. And some of the factors that go into AI usage is basically proficiency, efficiency, time management, as I said, predictability, and these various optimization growth. These are the features that go into this ADR mechanism, as we so-called call it. Now, what has been the one? Let me start for a moment with some of the few negatives that have come out with development. So ChatGPT, everybody is considering using it. Incidentally, I've never used it. I only talk about it sometimes. But we've had the US case where you've had various hallucinations. Now there is a word called artificial intelligence hallucinations. So AIs hallucinate, as human beings also do. That hallucination might cost you. So it did cost these two lawyers $50,000 fine because AI hallucinated, gave them cases that didn't exist, and that fine apparently has been levied. So today, coming to a position where most countries have started either doing or considering, requiring a verification by counsel of the artificial intelligence. So that is one networking that is there. Secondly, a very important argument that is made for artificial intelligence is the fact that it is supposed to be free from bias. So you say humans are biased. Artificial intelligence is a machine, it's not biased, but is it not? So when basically Google had its system and you had BARD, which went into a gender diversity. So the engineer who put in the system puts in the system of gender and diversity, and that when you're looking for founding fathers, picks up a Hispanic lady because the bias of the system was gender and diversity, and therefore it went on to that. So therefore, everything is built upon we humans built artificial intelligence that ultimately is responsive to the same kind of responses that do happen. And another interesting discussion, which is an academic one, but Plato's law of the lands. So an Oxford professor basically has done this analysis between a free doctor and a slave doctor. So a free doctor is trained, he imparts knowledge to the people, to his patients. The slave doctor just tries and then carries on forward with whatever he keeps developing down the line. So the question was, who's better? The free doctor better or the slave doctor better? Both of them treat the patients in a good way. So ultimately, you have a good result, the patient is free of disease. But when you talk about the positive points of what is good, so the free doctor interacts. The free doctor explains. Free doctor is actually the trained doctor. So let me modify that statement in case it's got wrong. It's not, he doesn't do it for free. But the point is, he's a trained doctor. He interacts with the patients. He uses the knowledge and adapts the knowledge as he speaks. A slave doctor, on the other hand, there is no interaction with the patient in a manner that is required. There is no predictability, and there is a difference. So this is the crunch of broadly what the little bit of negatives that might be with artificial technology. But having said that, let me come to the point at hand today. So we are using and will possibly use in various directions. So I'll just put out 5 different aspects for you in terms of artificial intelligence in ADR. And incidentally, in ADR, we've used technology and artificial technology even more wisely than we have possibly used in the legal dispute resolution system, so to say. And therefore, we have one up here. The question we use it is in discovery. We use it in analyzing documents. Now, they are voluminous documents, and AIs have the capacity to identify. So, a word search, for example, would take you down the system and be able to identify from reams of paper and reams of words that come across what you need to have. You have a system in artificial intelligence of something different from regular intelligence to generative predictability. That is where some of the question marks come. Can you have artificial intelligence do written submissions? Can you have artificial intelligence become an arbitrator? Being a counsel in arbitration is one part, become an arbitrator. What would be the regulatory system that would actually prevail for such arbitrability of a system, the arbitrators or the counsels that undertake these artificial intelligence? So with this, I'm just leaving the floor open. I've just tried to flag through for us what the concerns are both ways. There is no question that technology is here to stay, but the questions that need to be addressed as we develop these systems, as we evolve these systems, are some of the part of the processes that we will use to improve ourselves and to bring our system into tune with today's time and age. So let me go back a bit, Ganesh. If I might start with you. Sorry. So we were talking about NN Global, and I just flagged that, of course. I'm sure you will enlighten. So there are various aspects of NN Global, and NN Global actually proved to be quite a marathon by itself. 3-judge bench, 5-judge bench, 7-judge bench. What is your really take on this? One is, of course, the insufficiently stamped. Your take.
Thank you. It's indeed an honor to be on your panel, chaired by Ms. Anand. Always an inspiration for all of us like Ms. Luthra. They are always there to guide us when we come and do these arbitration events in spite of their very busy practice. And thanks to ICA for inviting us to be part of this wonderful event in Goa. Mr. Chawla, Amit, Ashok, all of you, thanks so much. On this issue of stamping, I think it is extremely important because, as you all know, and I'm sure many of you have attended a lot of these arbitration conferences and training programs, one of the first aspects we say is arbitration can happen only if there's an arbitration agreement between the parties. And it's usually embedded in a contract where it is an arbitration clause, or it can be a separate arbitration agreement which is entered into after the dispute arises. When we talk about the usual arbitration clause in a contract, we also, you might remember, we always speak about something called the doctrine of separability, right? So there's a huge contract, there's one dispute resolution clause which has an arbitration element in it. And the law is this agreement to arbitrate is separate from the main agreement. So even if your main agreement, let's say, is not enforceable, this arbitration agreement stands by itself and it should be enforceable as a separate agreement. This is called doctrine of separability. And the person to decide whether this is correct, this agreement is all right or not, is the tribunal. And that's called the doctrine of competence, where the tribunal would decide whether it has jurisdiction to deal with this case or whether this agreement is proper. That is the broad basis on which these line of judgments have arisen. See, a precursor to what ma'am said before NN Global, there were two decisions of the Supreme Court in SMST and Garwar, where the courts observed that if an agreement is invalid because it's not stamped. See, the Stamp Act in India says the agreement has to be stamped. It's not stamped, it's inadmissible in evidence. So therefore, if the agreement main contract is not stamped, the view was that an arbitration clause contained in that agreement would also fall, and you can't really enforce that. But then came a 3-judge bench of NN Global, where the judge observed that no, this is a doctrine of separability is there. Therefore, even if the agreement is not stamped, the arbitration clause should stand because it's a curable defect. I'll come to what the curable defect is. But then since there were differing opinions, it was referred to a 5-judge bench. This was called NN Global 2, where the Supreme Court, the ratio of 3:2, the majority decision, went back to the old position that if the agreement is not stamped, then you cannot rely on the arbitration clause. Why is it that these came up before court? Because all of you know that for an arbitration, the first thing is you need to get your arbitrator appointed. So when you file a Section 11 application before the courts for an appointment of arbitrator, now prima facie, as per the current law, the court can only look at whether there's an arbitration agreement. But if the contract itself is unstamped, can the court appoint an arbitrator was an issue, right? So if it is an unstamped contract which contains an arbitration clause, the majority in NN Global 2 said, no, you can't because the agreement itself is invalid. So, but this created a lot of practical difficulties because, you know, in a country like ours, there are so many contracts, small, big. And if you look at engineering projects, there are so many work orders, purchase orders, which each state has a separate Stamp Act amendment based on the central government, central legislation of 1899, the main Stamp Act. So you would Goa would have I think it has a recent 2023 amendment as well to the Stamp Act, for example. So now what happens? I mean, all these agreements go out of the window. So then this was referred to a 7-judge bench. Right? Then that was called in re interplay between agreements entered into under the Arbitration Conciliation Act vis-a-vis the Stamp Act. So the Supreme Court now, after very careful deliberations on 13th of December last year, 2023, very clearly said that arbitration clauses contained in unstamped agreements are enforceable, but they are inadmissible in evidence till the defect is cured. So what it means is when a court is faced with an application for appointment of arbitrator, and let's say the agreement is not stamped, the court can go ahead and appoint the arbitrator, and it's up to the arbitrator parties to tell the arbitrator that this is unstamped and therefore it cannot be admitted in evidence, and it's a curable defect. Then what the arbitrator has to do is impound this agreement, send it to the stamp collector, and they'll have to pay the necessary stamp after the stamp collector determines the stamp duty. In most cases, there may be a 10 times penalty, and then you pay it, the agreement comes back, and then it becomes enforceable. So therefore, this judgment is a very welcome step, because but for this judgment, all these agreements would have been in limbo. You need to probably, the reluctant respondent is never going to agree to help agree again for this arbitration. So therefore, this is a curable defect. You can go to the stamp collector and get it stamped. So the moral of the story, Madam asked me, what is your view on all this? I think as lawyers or in-house counsel, when we look at agreements, when any client comes to us, or when you as in-house counsel draft something, just to save a few hundred rupees, please don't do the mistake of not stamping your agreement. Just go get it stamped. It's extremely important. And if even before a dispute starts, if a client comes to you and you have an agreement, try and rectify the defect as soon as possible. In fact, we were advising somebody recently because there was an issue in an arbitration where after the evidence was filed, because of the NN Global 2, the other side very smartly took advantage of that and said, hey, these are work orders, they are not stamped. And under the Haryana Act, because it was a Gurgaon-based company, the entry is not there. So miscellaneous is 100 rupees. It was just 100 rupees stamp which these guys didn't do. So we had to spend about 6 months going to the stamp, asking the arbitrator to impound it, go to the stamp collector. But they say getting within 5-6 months is an achievement. Because once it goes into the stamp collector's office, it can take forever. So I guess that as lawyers, we need to immediately tell our clients that please, even if it is, even if you have 1,000 agreements in a month, it's worth it to get them stamped.
So, two takes on this. The moral of the story is not a penny less, not a penny more. So, it's all about a penny. And secondly, Ganesh Chandru is going to raise a bill for advice to all the lawyers here. He might finally make it nil, but it's good advice. And actually, there's a third point to this, which he's already said. The fact is, this reflected the Indian court's decision, desire, the Indian ecosystem of boosting arbitration. Because this was very important, and you don't know how many cases were pending. I do, and we were party to this. And this changed the landscape of what it is. But having said that, the Stamp Act proceedings take a long time to Ganesh. So I think we have to reform that part of the system also, where we expedite in case of curability. So Tejas, as you heard, Tejas and Ganesh, in this order, yes, are the one voice, actually there are two, but in one unison. They do take a position in law and arbitration, which really changes the landscape of India. So Tejas, in the morning, Justice Sonak was talking about the ease of doing business and the identification of the marking, etc., as what India is doing. But do you think that we have done enough, or do we need to do more in terms of promoting the ease of doing business and to inspire investor confidence? Because until we inspire the confidence, we will be engaging in the process of learning arbitration, but not being able to effectively exercise it. So we all want to know what do we do and what have we done to inspire this?
Thank you so much, and good afternoon all. Thanks to ICA for organizing this great event in Goa, and it's a pleasure to be here. Now coming to the question which is posed to me with regard to what we have done and where we have come so far. In the inaugural session we heard is that we have achieved a lot and we can do much more. The only question comes is the enforcement of the awards. Whether we have done enough to ensure that the awards are enforced in a time-bound manner once the arbitration is done, and especially foreign awards, because if to bring in confidence of the investor in India, where the assets are located in India and the award is passed outside India, India being signatory to the New York Convention, have we done enough to inspire that kind of a confidence? So what we have done from 2015 onwards, the amendments we have in our Arbitration Act, we have changed the definition of the court for international commercial arbitration and especially foreign awards, where irrespective of the original jurisdiction of all the high courts, there are few high courts which have the original jurisdiction, but others where even if there is no original jurisdiction, the enforcement of the foreign award will straight away go in part 2 to the high courts. So that has brought about a very welcome change. The second thing we have done is narrowed down the definition of public policy of India. And earlier we used to have quite a few awards not getting enforced on the ground of being against the public policy of India. That has also been streamlined. We have also not made it compulsory to bring an original award here, and even duly certified copy would be sufficient. Indian courts have also passed judgments to say that to expedite the entire process of enforcement of the award, especially foreign awards. What we have done is also to ensure that the maintainability and the enforceability have to be decided together rather than having two rounds of the same sort of argument about the maintainability. It has to be decided at the same time. In terms of appeal, there is only one way appeal under Section 50 of our Arbitration Act, and that is only if the enforcement is refused. If the enforcement is granted, then there is no appeal, and therefore the award has to be enforced in the manner of the arbitrators have decided. There is a very limited scope to refuse the enforcement of the award, that is on the procedural grounds and the public policy ground under Section 48. In fact, in Vijay Karya case, which was referred, the court imposed a cost of 50 lakhs for raising frivolous resistance to the foreign awards enforcement. So there is a deterrent. Indian courts are now alive to the expeditious enforcement of the foreign awards. Apart from that, foreign award, as Ganesh was mentioning, that arbitration agreement is required to be stamped, but when the awards in India, if the awards are passed in India, is also required to be stamped, but the foreign award is not required to be stamped, and therefore it is easy to enforce the foreign award as it is. So that is as far as foreign award is concerned, and a lot of arbitration happen in India also. So we have international commercial arbitration seated in India. We have changed the law to bring about the change to making a compulsory deposit of the awarded amount before the award enforcement can be stayed. So earlier there was a impression that the automatic stay is granted as soon as you challenge the award. But now we have the provision under Section 36, which requires the parties, and the courts have taken a view that parties have to deposit, the unsuccessful party has to deposit up to 100% awarded amount, and that has reduced the challenge also to a great extent. Other than that, we have introduced the timeline of 1 year to be for deciding it. In practice, it is not followed because of the backlog of cases. In one of the cases, the Supreme Court has held that timelines are only directory and not mandatory. But as far as in a timeline for the passing of the award under Section 29A is concerned, it's strict because the mandate terminates of the arbitrator unless the court has extended the time. Similarly, we should bring in some kind of strict timelines also. Of course, it's not possible to comply with it, but some sort of discipline is required because the biggest complaint we face is the delay in enforcement, not only by the court, but also because of the actual enforcement takes away a lot of time in identifying the assets and forcing parties to pay up, because unless there are assets which can be sold and the parties have preserved the asset, is very difficult to find. So asset tracing is also very important aspect when we come for enforcement, and taking interim measures after the award to protect the assets is important to ensure that the enforceability takes place. So it is a combined effort between the lawyers and the court to ensure that the enforcement takes place in a speedier way. Apart from that, we have done a lot of other changes under the Arbitration Act, but in my view, this is the very important aspect about enforceability of the award. And if we fix that, we will be able to increase the confidence of the investors to come to India, and it will obviously lead to ease of doing business in India.
Thank you, Tejas. So just two quick comments and we'll take it further. So I don't know how many of you know the White Industries case. I guess most of us know this famous case which cost us millions of dollars and which ultimately changed the whole way for the international investment arbitration regime as well as the international arbitration regime. But some of us might not have noticed that White Industries ultimately we lost not on merits. that money was to be paid not because we had a bad case or somebody owed somebody something, but the fact that there was delay in the Indian system. So delay has been one of the problems that we've been having, the backlogs and the non-disposal, which cost us a lot of features. And today the attempt is to shift that focus around to ensure that there is timelines as there is in Section 29 of the Arbitration Act. Incidentally, while I was doing an arbitration, I suddenly realized my last day had come for giving the award. I was a presiding arbitrator. I could have taken time from the court or the parties could have taken, but I said, no, it'll go in today because this is the last day. So I think we need to be brought to task from time to time so that we actually perform within those timelines and not directly. They should remain mandatory. Don't give any margin. There can't be margin and there shouldn't be margin in at least some of the provisions. And also, Tejas, I remember the law minister was sharing that the commercial court's disposal had shifted from about 1,000 days to about 400 odd days. I'm just giving a general figure. Of course, this is not true of all cases, but the average from 1,000 days for a case to be disposed of in arbitration, in the commercial courts, it came down to about 400 days. So having said that, Mumtaz, since you joined us, and by the way, Mumtaz is, as was announced, she has a 16-year dispute resolution practice and active arbitration career, and she's gone through with various firms and continues to be with ELP. So Mumtaz, what do you think in terms of institutional? You are sitting in an institutional-led conference by the ICA, but what do you think of institutional versus ad hoc arbitration and mediation? And do you think there's enough support for the institutional setup as far as the Indian legislative system is concerned?
Thank you, ma'am. Thank you, ICA, for having me here. As regards institutional arbitration and mediation, I feel whenever the word alternate dispute resolution was taken, it was always invariably referred to as arbitration. Mediation was always like a side thing which somebody may or may not have gone into about 2 decades back. But when arbitration started picking up, I still say that India is traditionally, while we are sitting in an institutional setup, most of the arbitrations in India are ad hoc, and we are trying to still institutionalize them. Mediation, the efforts began way back in 2005, but we are still just a foot in the door, because while the Arbitration Act of 2019, which was based on Justice Sri Krishna Committee, which heavily spoke about institutionalizing arbitration, we've not seen that hitting the, while the Arbitration Council of India set up and everything, all those provisions have been notified, but we are still evolving and getting to a system where we are completely in an institutional setup of arbitration. While that dream has still not been fulfilled in over 2 decades, I feel that mediation is still a far-fetched dream. It's still not taken as a very, very serious method of alternate dispute resolution, but with the Commercial Courts Act, with bringing in the mandatory pre-litigation mediation, I think there is a lot of effort that has gone at the legislative aspect. Even the data protection bill, although Section 31 has not been notified, but it talks about mediation as a method of resolving disputes. So while the legislature is taking steps, there are recommendations for building the Mediation Council. The Mediation Act 2023 has been brought in. The sections regarding the council have been notified. But the point here is what brings in the change. The change is brought by the mindset. Today, as lawyers, we have to bring in a change in our mindsets and see how we weigh in arbitration and mediation as dispute resolution measures. It's more often than not counsels that advise the clients that, at this point in time, you need an urgent relief. There is a subject matter preservation you need. Please run in for an arbitration. Don't go in for a mediation. So there are a lot of disputes which can actually be settled at a very nascent stage. When Justice Vishwanathan was asked to, when Law Secretary Vishwanathan was asked to give a report on the IBC reforms, he had suggested that there should be a mandatory mediation even before an insolvency process begins. All these are steps in the right direction, but today, is there institutional support for mediation for clients and lawyers to get that kind of confidence? While the Commercial Courts Act brought in the requirement of a pre-litigation mediation, but what is the quality of mediators that we have today is also to be seen into. Mediation is a specialized field where two people who have varied thoughts and have varied views about a dispute, they have to be brought on the same table by somebody who has the expertise to bring them on the same table. Now, what is the fee schedule given under the commercial court rules? Maximum fees payable is 75,000 to a mediator. So, how do we ensure the quality and the trainings that are provided to the mediators? I feel institutionalizing things gets better because institutions have their own rules before they rope in and they impanel somebody. So if, like for example, I come from Delhi, Samadhan is working beautifully well in Delhi for the last so many years. But one of the main prerequisites of Samadhan is to be a Samadhan qualified mediator or empaneled mediator, you have to undergo a mandatory Samadhan training. So those are the steps that I feel are very, very important if we need to give some serious credence to mediation. Laws are there, laws will be there. Enforcement of the law and application of the law, implementation is what we seriously lack. And while there's full focus, the Consumer Protection Act, the section is not notified, but also talks about mediation. There are several legal provisions which mandate mediation. We have had Section 89 of CPC since a long time. But today, to build that confidence, we need to have the clients understand that yes, there is an institutional setup. Yes, it's going to be impartial, it's beneficial, it's quick, it's expedition, and somebody who's doing it for you is somebody who's experienced to do that. In the previous panel, there were discussions about MED-ARB-MED. I strongly feel that a mediator should never be an arbitrator because you have to have that element of independence when you are deciding and trying to persuade a party to come to the table and settle a dispute. Now, it's very hard to get over that hat and come and sit as an arbitrator while you have access and privilege to information that you may not have as an arbitrator when you're sitting as a mediator. So while it's, like I said, it's a foot in the door, but it's a long way to go. Thank you.
No, thanks, Mumtaz. Actually, I quite see your point and I quite subscribe to the same. Whether you can have a mediator as an arbitrator is a moot question. I will leave it for the audience to figure out their own priorities. But I definitely think if I was a client, I would want to go to a mediator feeling that the mediator will not disclose that information or be privy to that information which I gave only for settling the matter or for the mediation. That should not be a matter available and open for content before an adjudicatory mechanism, whether arbitration or litigation. But as I said, everybody has their own viewpoints on it. But confidentiality and indeed accuracy in these issues is very important. But just on the lighter side of mediation and arbitration, ultimately there's one belief I have. In fact, the New York Times had interviewed me recently on subject regarding the Indian legal system. And I do feel that people in India do litigate because there is this belief in the legal system right up till the end, right up to the Supreme Court, whichever way it goes, through arbitration route or the other route. Secondly, I feel that there is no understanding of the costing which it costs you to finish a matter prior to actual litigation by any pre-litigative mechanism. Thirdly, just a comment on mediation. When the Mediation Act came following the Singapore Convention, there was a whole debate whether it should be made mandatory or voluntary. Finally, it was left to make it voluntary under the Mediation Act 2023. But honestly, to my mind, the opt-out, opt-in system was a better one. At least make two mandatory conditions and keep an option for opting out. So it's like a bill that you are charged 100 rupees, whether you like it or not. If you don't want to be charged, you must advise. So this opt-in, opt-out principle works possibly better, but these are some academic comments and some professional comments from knowledge. So we will keep taking them up from the audience also. Ganesh, we've been talking a lot on pro-enforcement, the Indian mediation and other backgrounds. Let's come a bit to technology. So what do you think in the backdrop of increased reliance on technology, there seem to be two major factors: safeguarding privacy and confidentiality in ADR processes. What is your take on this?
Thank you. I think one aspect you did during your introduction, start of the conference, I think, very helpfully laid down various facets of our dispute resolution process where technology is used, right from the documents, then e-discovery, then the hearing proper. I think one thing which all of us are doing on a day-to-day basis now, e-discovery and all is not done as a regularly, but hearing itself, virtual hearing has become extremely common in arbitration. Like they were in litigation during the pandemic, and even now you can opt for virtual hearing before the courts as well. They do permit you. But in arbitration, except for the cross-examination, I think now it has become a new norm. At least in most of the cases, your preliminary hearing, your other aspects of the hearing, legal arguments are, it's not uncommon for it to be done virtually even now. That being the case, privacy and confidentiality is a big issue. How do you tackle it? There are various institutions which have come up with protocols that you need to follow if you're having a virtual hearing. For example, you have the IBA, you have Chartered Institute of Arbitrators, you have ICC, SIAC, and here in India, the Indian Arbitration Forum. They came up with something called a virtual hearing protocol. But what you need to do, which is practically which we do in international and other big arbitrations as well, that when you have a major hearing coming up which is going to be held virtually, the parties need to agree on a remote hearing protocol. That's extremely important. And as a first step, even before you go to the hearing, as arbitrators, I think many of you will be acting as arbitrators or already acting as arbitrators. In your first procedural order, that is after your preliminary hearing, I think you should record the understanding of the parties if they are both are agreeable, that you could have the hearings either physically, virtually, or in a hybrid mode. You should agree that up front, so that first you have agreement of the parties, so that one party cannot tomorrow turn around and say, I never agreed for a virtual hearing, it was thrusted upon me. So record the agreement in the procedural order. That is the first step. And before a virtual hearing, when you really have it, agree to a remote hearing protocol where you will put all the details as to what technology will be used, what platform will be used, like Zoom, or whether you will be using MS Teams or WebEx. Put that there, and how the witnesses are going to be examined, how many witnesses on each side. You can name them if you want. And it's very, very important to have a test run. If you're going to have a completely virtual hearing, where you will have documents to be exhibited virtually, I think you should have a e-hearing bundle, which is to be done by both the parties. And that should be kind of numbered in a certain way. And you have a test run. You have a 1 hour. Usually, if you have a transcriber, for example, there are providers like in international arbitration, you have a provider like Epic, Singapore, which they will help you do this test run, where they would say that, the arbitrator and the counsel for both the parties and the parties will also participate, so that once the hearing starts, there's no confusion. And you have a list, and once on the hearing date itself, you should start 15 minutes before, make sure all the participants are there, and then you should not allow the moderator who's going to be allowing people inside should not allow anyone else whose name is not there in the previous list. So that way, confidentiality is definitely maintained during the virtual hearing. Cross-examination, of course, is really tough if you're going to be doing it very remotely. You need to have a 360-degree camera. One practical tip you can do is, if you have an office in that city or you have an associate office and you agree, one of your lawyers can go and sit there to make sure the witness is not being coached by the other side's lawyer. That's something you could do. This, I think, is the best you can do in the current circumstance, where you maintain confidentiality, but still you use your technology so that you end up saving a lot in cost. Because except for the cross-examination, in my view, I think most of the steps can be done virtually if you can. So technology is definitely a boon, but you need to take care. I think there's some other aspects of AI which I think Mumtaz will be dealing with in terms of the documents and e-discovery. Those aspects, I'll leave it to her to deal with. On virtual hearing, I think you need to follow this protocol. That's extremely important.
So I think Ganesh did well to talk about the hybrid systems that were evolved during COVID times. And indeed, as I've experienced and we've been doing, two things come out, that we've been using technology for online hearings far more in ADR than possibly in litigation, though we've been very efficient, incidentally, in courts also. So we were better off than UK, USA, I can tell you personally. All the figures show that, and Indian Supreme Court, the High Courts, Goa, everybody was equally effective. But ADR continued to use the systems far more efficiently, and broadly it's become settled. We are doing it every day. The procedural orders, right up to the stage of literally evidence, either chief or cross, we are doing it through virtual means. Just day before there was a hearing. So there were two lawyers. One was from Jharkhand, one was from Bombay. So the Jharkhand lawyer wanted online. The Bombay lawyer wanted offline. The arbitrators, one of the arbitrators wanted offline, another one wanted online. Anyway, the long and short is that the broad consensus, because it was a procedural hearing, it was agreed very clearly that it would be online and we would only go on to offline, even though the agreement itself contemplated offline, by the way. But it is open to the arbitrators and the parties. Ultimately, consent and party autonomy is the biggest thing that prevails. So this is good news for all of us. So with this kind of thought process on privacy and confidentiality and the process of technology that Ganesh just spoke about, Tejas, what about the use of electronic communication tools and digitally signed documents, which has become the norm in undertaking global commerce? When disputes arise, digital evidence plays a very pivotal role in resolving disputes. What is the state of play regarding digital evidence? And I have one more question, which we were talking about just yesterday between my colleagues and us. What do you think the new Bharatiya Nyaya Sanhita might have an effect on arbitration? We have a lot to do with technology and digital evidence in the new law that will be ultimately effective as of July 2024.
Yes, so what we have seen is that all the communication in last decade or so is in the electronic mode. Even the contracts are getting signed. We are getting into the whole concept of metaverse, where you will have the cryptocurrencies and you will have the digital assets which you will have. So digital assets or electronic evidence is going to be the norm, and we cannot ignore the existence of the electronic evidence. Then the question comes is that how do we prove it? How do we present that particular evidence before the tribunal? And what is the procedural requirement for appreciation and admissibility of that? So first, the threshold is admissibility of such evidence. Now, when we talk about an evidence, the best evidence rules apply, although Evidence Act or the new Bharatiya Sanhita which comes into effect, will replace Evidence Act, has no direct applicability to the arbitration proceedings. In fact, Delhi High Court has also said that Section 65B, which requires a certificate to be given along with the printout, because what happens when the evidence or any document is stored electronically, original of that particular evidence is in the hard drive or it's in the electronic form. What we are taking a printout is a secondary evidence. Because it's a printout and it's a secondary evidence, it's not the best evidence. So the best evidence rules requires the original to be produced first. That is not possible because original is in an electronic form, and the way it works is that you have to certify that this particular printout is taken from the computer resource which was functional and who had the authority to have the control over that particular computer resource. Under the Information Technology Act, the electronic contracts and electronic signature are defined, and also the Evidence Act was amended under Section 65B when Information Technology Act came in 2000 to have this mechanism whereby the secondary evidence becomes the primary evidence by way of that certification. Because Evidence Act does not apply, and the 65B in the new Act is also replicated in Section 62 with a proper provision which is identical to the existing provision with regard to the production of the documents which are stored electronically. We have seen that even after the new law comes in, the same process will follow. But as far as arbitration is concerned, since the arbitrator is not bound strictly by the rules of Evidence Act, although the principles of Evidence Act would apply, and the admissibility, relevancy, and materiality of the evidence is left to the discretion of the arbitral tribunal in an ad hoc arbitration, and also in some of the institutional rules, you see that the electronic evidence-related rules are also present in some of the international arbitral institutions' rules. we have to see each and every case and ensure that the electronic evidence is placed on record and an opportunity is given to the other side to comment upon a existence of that document. As far as contents are concerned, that can be read by the tribunal in the evidence. But as far as the existence is concerned, now mostly all these evidences are electronically stored and they have responses to each of these mails. So there is no problem with regard to production of this particular emails are concerned if the parties have contemporaneously exchanged the document and they are relying upon it. So mostly we see in arbitration these emails are taken on record without any requirement of a formal proof of this electronic evidence. The only question comes is when there is a disputed question. And in one of the cases which I was doing, there was an oil and gas arbitration where the operator had to plug the well and they had given the notice to all the joint operating agreement members to object to that. One of the members objected by email, and the question was the main question in the whole arbitration, which had a huge claim because of unauthorized plugging of the well. Plugging of the well is that you pour concrete in a dry well so that you don't incur further cost. They plugged the well without waiting for the email. The question was that the email was received prior to plugging of the well or after plugging of the well. And we had to go into the expert evidence of the server because as per the Information Technology Act is concerned, as soon as the email is received by the server, it is delivered. It's not that you have to open the email, and the same logic used to apply for the fax also. In old days, we used to have fax. Moment the fax is received, it is delivered, and you don't have to, when you used to have an OK taken on the delivery report. And reading is not important as far as email is. You don't have to open the email and read it. And we could show from the server logs that the email was delivered in a particular date and time on their server, and which was prior to the plugging. Therefore, it was held that. So these are all aspects of the digital evidence or the electronic evidence, as we call. And ultimately, it all depends on the arbitral tribunal's understanding of the rules of evidence applicable to the either the place where the seat law, where the seat of arbitration is, or internationally best practices. Like IBA rules on taking evidence in international commercial arbitration has parameters on how to produce evidence, including electronic evidence. And therefore, we have to follow those best practices. What we see is that e-discovery, in which we will talk about it briefly, Mumtaz will deal with it, is that a lot of documents are stored in electronic form, and therefore e-discovery is a very important tool. There are softwares now which deal with the e-discovery, and when it's produced pursuant to the request for those documents, those are also taken on record and tribunal can read into it to understand it. So difficulty is that the electronic evidence is mostly scattered. You have so many mailboxes, when you are called upon to produce emails regarding a particular issue, and there are multiple employees, some of the employees leave, therefore to retention of the electronic record is also very important. And you need to, every company or the corporation need to have the proper policies of retention of the electronic records, and maintaining authenticity is also very important, that tampering with the electronic evidence is easier than documentary evidence. Therefore, it is very important that when a printout is taken, there is no tampering done with the electronic evidence also, so that later on the award is not challenged on those grounds of not or relying upon evidence which is not appropriate. So therefore, we have to be very careful while appreciation and admissibility of the electronic evidence. And it's the strict rule of evidence does not apply to arbitration, but the arbitrator has power to deal with the manner in which the electronic evidence can be produced in the arbitration proceedings.
Thank you, Tejas. I thought this point was rather important because really speaking, evidence as counsels, all of you are counsels, or a lot of you are, takes up a lot of your time and space. And the manner of evidence, how you give evidence, how you prove a document, etc., is of great significance. So I did want Tejas, and he has done exactly that, to lay out the entire circumference of ADR, which distinguishes it from the other system. And that incidentally is a major component of the length of a litigation process. So this helps to reduce it with electronic evidence and whatever else follows. And he's right. I just put the Sanhita there for discussion. But really speaking strict to sensu, it may not apply because arbitrators evolve their own rules into a discussion process, unlike the normal litigation process. So, Mumtaz, here's a little quiz for us. A quiz for us. So, you have artificial intelligence as AI, and you have generative artificial intelligence on the other hand. So, AI is what I teach the system to do. So, I put in data, the artificial intelligence generates it very well, no problem. And then I have a generative AI, which is I give some data and then I ask the artificial intelligence to decide and analyze what to do and come out with something. So while we speak about e-discovery, while we speak about looking at documents, while we speak about transcription, incidentally, ladies and gentlemen, transcription is a very common feature amongst artificial intelligences. Is very good. Normally, in fact, all the conferences nowadays have transcriptions as we speak. Supreme Court, in fact, has a system now whereby you have translations through an AI system, which is proving to be decently effective. So we have all these systems. But Mumtaz, coming back, so with these systems in operation, will I be replaced by a robot as an arbitrator? Is there a possibility?
So,
should I be?
The answer, before I detail it out, the answer is no. No, that's not because I'm a lawyer or I intend to sit as an arbitrator. No, that's not the point. None of us can be away from technology or shy away from it for too long. When COVID began, just before the lockdown being announced, everybody in the law firm was paranoid. What's going to happen to the files? What's going to happen to the hearing? But within 10 days, our court system was all in place. Virtual hearings were in place. I think 22nd March was the lockdown and 31st March was our first hearing. So we can't be away from the technology. So using AI for document review, yes, definitely. Using AI to see, ultimately, what is AI? It's an algorithm. It's a software set in where you put in information and it gives a very, very generative output. Now, the problem here is, do we have the infrastructure? Do we have the updations? Do we have the guidelines and rules in place? Chat GPT, which everybody is talking about as one of the best softwares, it was last updated on 3rd May 2023. We are in 2024. When we rely on a machine to do something for us, what is the nature of algorithm? Who's feeding the algorithm? If it's a pre-fed algorithm, the outcome will be the same. So a lot of times there would be technical and high value disputes where you could not use them. I'll come to that later. There is a writ that is filed in Delhi High Court. It's called Chaitanya Rohela versus Union of India, where the issue of deep fakes and AI have been raised, and it's said that there are no regulations governing AI. So who actually analyzes whether there's a document uploaded for an AI arbitrator or an AI party to be analyzing if it's an authentic document? Who checks issues like whether it's an updated data? Now, there are a lot of situations where the facts may be similar and distinctive only on a very limited aspect. When you're putting it in an algorithm-based system, especially for a high-value dispute, the outcome may not be the right outcome. Now, there could be a robotic approach in that. There could be a very approach which is not in compliance of your law of the country. So again, the public policy question will come in. There are positives, like people will say there's no bias. Somebody who's doing it, there's no element of bias. Even if it's a single member tribunal, you know that the outcome is not going to be favoring one side. But issues such as what is the nature of the algorithm, what is the pre-fed notion in the algorithm, and then generating an output based on that, it's a very dark field, and I feel that that is not something we all should rely on for adjudication, because when we are getting to an alternate dispute resolution mechanism such as arbitration, which is binding, it's very important. It's a very important function, which is a judicial function. Now, it's a private fora that the parties have chosen. It just can't be mechanically put in a software where you don't know what the outcome is going to be if a human mind is sitting and distinguishing facts or appreciating evidence, and especially with a field like AI, which is so unregulated at this point in time. Maybe a decade and a half later, when the rules are in place, when there are enough and more softwares, where there are regular updations, I may take a different view, but as of today, when I know what are the nature of softwares available, what are the nature of algorithms that they follow, unless it's a very small value dispute, like for example, Estonia and China, for claims below a certain value, especially Estonia, if it's under 7,000 euros, you have an option to do it through an AI adjudicator, if not an arbitrator. But these things have not been tested on high value disputes, especially when we are talking about arbitration. There are commercial complex disputes. A lot of times when we talk about construction arbitration, the documents run into 40, 50,000 pages. Yes, for document review, if you want the documents to be segregated and an output come, yes, definitely there. But an adjudication on a dispute like that, I don't think we are going to be replaced soon, because the parties are never going to be in a state where they are ready to give it to a machine which is going to give a pre-fed output.
Thank God, Mumtaz. At least for the time being, you've rescued us. So we will still survive this. Anyway, the idea was really to show that when we are dealing with an evolving landscape, which is the topic of today's discussion and the panel, the idea is it's evolving. And Mumtaz is right, tomorrow what happens, we don't know. But today, what we are ultimately dealing with is the increasing use, and we are grappling with it. But one thing which comes out very clearly is this: while we deal with technology, because it is evolving, and continues to evolve, A, we need an evolving regulatory mechanism, and B, we do need a regulatory mechanism, and C, the regulatory mechanism has to ultimately be commensurate with private international practice as well in the field of ADR. Because what happens? Now, for example, we talk about the arbitrator, supposing it's a machine which is, actually, you do have online dispute resolution, does have such a system. So how do you hold an arbitrator has misconducted himself or is biased? Because all those issues would not be available to you. So anyway, at the end of the line, when you do evolve new systems, the law and the regulations have to come into perspective to be able to deal with it appropriately. And I'm talking about artificial intelligence without the robot arbitrator, even artificial intelligence per se. And this is the system we are grappling with. As I said, today you have e-filing in all courts, at least in Supreme Court and for that matter in Delhi High Court. You have e-filing. Now, who thought that that would be possible? So day before I was doing a matter in Supreme Court, and somebody, one of the briefing counsel said, I filed the application, and the application was filed at 12 o'clock at night. Similarly, there was some mentioning to be done before the chief in the Supreme Court. And the lawyers, there's a system now evolved by the Chief Justice, which is that you have from 10 to 10:30 in the morning, you have a mentioning slip being sent on the basis of which you mention, and between that timing. And this does happen. So here we are dealing with technology to aid us into working towards a fulfillment. You have the negatives ahead of you, but then any system is not perfect, whether it's human, whether it is artificial intelligence. The idea to nurture it and to rein it in to the extent that we can use it for our benefit, and definitely to learn. We need to be in tune with what is happening. So some of us learned and are learning. Some of you, the younger ones, have got that learning process, but believe me, there's always continuously learning. But as lawyers, we all know that. You're always learning. The learning is never over. So any last comments? Tejas, I'll take it from you.
Ma'am, just before Tejas sir says, 2 weeks back, even the district courts have gone online. So we went to file something and we were in for a surprise, and they said, no, this cannot be filed here. You have to online file it, serve the other side just like you do it in the High Court. And the rule came in that very day where they said now district court, every filing is going to be completely e-filing, where you have to serve the other side, and a notification from the e-filing system will also go to the other sides. So Delhi now, even district courts are completely e-filing since the last 2 weeks.
So the dispute resolution system is learning from the ADR system, and whichever way it goes. So thanks, Mumtaz, for that. So we are really getting far in this world, and we're all evolving ourselves. Just your comments on the subjects.
Yes, so as I feel technology is here to stay, we are all surviving because of technology. And unless we adapt the technology, it's very difficult for us to survive, because what we are planning now is also developing the platforms which will have everything online in the arbitration system also. So instead of sending emails, what we can do is upload the documents on a secured server, which is a password protected. You have two-factor authentication where you have your own space to upload both sides, and the arbitrator and the arbitral institutions will also have their login. So that becomes very easy to manage the document. Everybody can access the documents. You don't have to carry the documents for the hearing. You can log into the system and access to those documents. What also happens is that instead of sending emails, you can apply for adjournment and the hearing can be scheduled online. There are virtual platforms. The AI can also, now we see the captions which comes on lot of platforms like Zoom or WebEx, whatever we speak comes, it is also fairly accurate. And with the AI and human intervention, we have Terrace, which is being used by Supreme Court, and I used it in one of the arbitrations, and it was perfectly fine. So AI has changed the way we do arbitrations also. Of course, it cannot replace the arbitrators because you need reasoning, because there is also an element of bias in the data set which we feed into the AI. So it's a big concern of the due process, which we have to keep it in mind when it comes to the decision making. But in all other aspects, I think AI can be used, and we have been using AI to our advantage when it comes to transcript, virtual hearings. What was also told is that if we're doing cross-examination, AI can help you to identify contradictions in the transcript. So if a witness has given an answer and you are getting another answer which is contradictory to the previous answer, it can also help you. Of course, it is subject to human review of the person who is doing the cross-examining. But it will help you to reduce the time and cost into arbitration, which will be a great benefit and which all we should take to our advantage. Thank you.
So thanks Tejas. Before I ask Ganesh for his winding comments, any questions from the audience? Identify yourself, please, and ask the question. We'll take maximum 3 questions.
Madam, I'm Advocate Pooja. I practice at the principal seat of Bombay High Court. My question is very short. Madam, when it comes to environmental civil disputes, how can we bring arbitration into picture and how can we succeed in it?
I'll supplement.
I'll give my view. So I feel that there are specialized forums. You're talking about environmental disputes in general, environmental disputes, or environmental disputes in deciding, in conducting arbitrations?
Environmental disputes in conducting arbitration.
So that's what the benefit of technology is, because if you're reducing the use of paper, now like I said, that there are bulky filings that happen in arbitrations. Everybody wants to do an arbitration so long as they start seeing the paperwork involved in arbitrations. They're running into thousands of pages, and then when you have a 3-member tribunal, I think the best step of a online arbitration or a hybrid hearing is, and especially this came in from the international arbitration systems where you were allowed to file online. I think that's the biggest step that has been there in preserving the environment, because when you're saving 3 copies of physical filings and 2 copies of the to the other side, you're doing your bit. Now, as far as electricity and all are concerned, they will still be there. If you need to use, so it's all a bane and boon. You have, you're saving trees and you're saving paper, but there would be some electricity that goes into using all of that online. But while we are more exposed to screen and doing that, but we are doing our bit by not using a lot of paper.
And then just to add to it, there's also a concept of green arbitration. And what we are doing by virtual is we're reducing carbon footprint by not traveling by air and allowing virtual hearing. Plus, paperless arbitration again is green arbitration. So always we should take a pledge and do green arbitration, which will help to preserve the environment. in that.
So just for record, ICA, for example, is having online filing for its own system. You can sit down if you like. So you really are developing this field, and as they just rightly said, it's a carbon footprint which is attempted to be reduced a lot. In fact, in one of the recent arbitrations, my co-arbitrator was saying, well, I decided to travel economy. Firstly, not to travel is one question, but economy instead of business because it saves gas. And it does. There is more gas consumed in the higher seats. I'm not sure this is the best desirable feature, but indeed, it's a matter of concern for everybody. So it is being addressed. And also for your reference, the question that was asked by Mumtaz, which are you talking about? So environmental arbitration also is a huge issue through the world now.
ESG.
By itself as a substantive issue, by the way.
ESG disputes is a huge.
Any more questions? Please.
Sir, it is other than this AI issue. Whether the government has formed the parliamentary committee, and what I know that his report has been submitted, but its content is not available on the. So, is anybody is having some?
So I'm a member of that committee.
Tejas is a member. The committee report has come in February, and I believe it's available. Tejas, you'll have to help people to get access to it.
Yes, so no, it's the giving access is not a problem, but then once it is a confidential report given to the government, and it's for the government to implement it. So we don't want also that report to become public, and then there is a comparison with regard to the implementation and the recommendation. For the recommendations, what we did as part of the committee is that we invited all the stakeholders, that is all the arbitral institutions of India, outside India, arbitration practitioners, and also many senior counsels were invited, former judges who are very active in arbitrations were invited. We went by section of the Arbitration Act and saw that where all we need to improve. Now, there are a lot of issues which, personally speaking, I don't agree in that report, but it was majority. So we have gone by the majority there. Some bits I can share is also with regard to, again, bringing in technology. So there is nothing in the act about virtual hearing. So we are trying to bring in the sanctity of electronic or virtual hearings on that. Some of the things which I don't agree is providing more appeal to the court, which personally speaking is not required. 34 will get streamlined a lot, and time for challenge will get reduced. There are a lot of practical suggestions we have made. The only reason why it's not public and it is in the limited circulation is also is that we don't want a debate on that report, and it is for the government to take it. The government set up this committee, and it's better for the government to implement the recommendation.
Thank you, Tejas. So, Ganesh, your last comments, and maybe then we can try winding up.
Yeah, thank you. So you had asked us to comment generally on technology. I think a lot has been said on the use of technology, discovery, documents, safety, evidence, and all that. But I think one thing which you started off this particular thing about AI is what you feed in and you get out as AI, and then generative AI, asking the AI to start thinking. That's where the danger is. I don't know how many of you here have seen the movie Robo or Endiran in Tamil, Rajinikanth movie. You've seen that? In that, they'll create this robo which exactly look like the hero of the movie, and ultimately they'll have to destroy it because it's such a technology that will destroy mankind. So that's what this movie was. That's exactly what is the danger. We should keep control of technology and not allow technology to control us. But that said, we are succumbing to it. In fact, there are reports which say that in about 10 to 20 years, 3 or 4 companies will control this entire world, right? But that cannot be allowed to happen. We should have control on technology, because if you think that, these are very useful tools, and this is not just for arbitration, generally for life itself. So I think technology is very useful. We should use it properly. but not allow it to go to such an extent that it will start controlling us. Thank you.
So I'll take the last line on this. Starting off from Ganesh, we'll try to wind up. I think the time is out. Maybe over tea, you can ask. But basically, the point being simple: human beings are more or less indispensable. We utilize our services, and we have something called the brain, which exists over and beyond other activities which are automatic in nature, or even automotive in nature, for that matter. So we need to retain the balance for everything. We need to expedite processes, and we definitely used to harness whatever energies we have. It's like we go from petrol to diesel to CNG. And similarly, we keep using technologies, hydrogen, but then whenever there are flaws, you find them. So you retain the human capability, the human analysis, the human sensitivity. At the same time, you use it all for those purposes: transcription, translation, e-discovery, to the extent you can. So whatever you feed, you get out. I remember my first searches on these programs. So you put in the word. So sometimes later when my juniors do research and they say, "Madam, nothing is available," I said, maybe you didn't use the right word. So you have to use the right word to get the right answers also at times. That is the prescription for all of us here. We as lawyers are fortunate, very fortunate. We're always ready to learn. And we're always learning, whether we are ready or not, but we are always learning. And we have to do that. So in this arbitration technology process, the new landscapes, particularly international conflicts, and particularly considering that Goa might soon be entering into this domain of becoming another seat with the Goa High Court and the Chambers of Commerce, which we are mooting. We hope that we can put our minds together, use our hearts together, and put together systems constantly, and thank God for evolution. We need to evolve, and we'll continue to evolve. So thank you very much, ladies and gentlemen. With this, we wind up the session.
That discussion has truly widened our perspective and given us a lot of food for thought. Thank you all the panelists. And thank you all for being here and being such a great audience. We would now invite you to join us over high tea. Thank you so much.